Okay, good morning. I'd like to call to order the Judiciary Committee meeting of Monday, March 27th. And we will be adjourning for a recess for caucus. And the two caucuses are meeting where they're meeting. We stand in recess until the caucuses are over.
Just for a point of clarification, Judiciary Committee is going to recess for caucus right now.
Correct.
Okay, thank you, Representative.
Good. All right, I'd like to reconvene the Judiciary Committee meeting. Folks could take their seats. Welcome to JF week. Any remarks from my co-chair? If not, let's get down to business. I will entertain a motion to JF Senate Bill number 5, which is number 1 on our agenda.
Second.
I have a motion from Senator Winfield, a second from Senator Kissel. Is there discussion on this bill? Senator Winfield, do you want to explain it first?
Yeah, this is a bill that comes to us through some work of Senate. It's looking to provide greater protections for individuals involved in domestic and intimate partner violence. It makes a program in each judicial district dealing with electronic monitoring. It has provisions when alimony would not be something that could be collected by spouses who've committed certain crimes. And then there's a report back to the committee whether there should be a sufficient number of grant recipients to administer program in the courthouse. It's a great bill, ought to pass.
Senator Kissel.
Thank you very much, Chairman Staffstrom. I'm also happy to support this essentially a Senate Democrat initiative, Senate Bill number 5. There's a lot of good stuff in here. I think that regarding the ankle bracelets, I think that was an idea that, to my recollection, was first offered by former State Senator Art Linares, but its time has come. Also, regarding the alimony, that just seems a simple case of justice. Certainly, you wouldn't want the perpetrator of harm and crimes to then be the recipient of alimony. It's just makes no sense to me. There are certain financial implications, so this bill will have to visit appropriations, is my guess. But Connecticut has been a leader regarding domestic violence over the years, and this is another good step to move us, to keep us in that position of leading the nation when it comes to legislating to try to protect against domestic violence situations. So I'm happy to support it. Thank you, Mr. Chair.
Further discussion on this bill? Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I am in favor of the bill that's before us. I will flag, however, the alimony aspect. As discussed at the public hearing, I believe the discretion of the court, given the confines of the statute 46B82, provides the court with a amount of latitude so that they can take such a situation into its deliberations and the finely crafted mosaic that is rendered in a divorce matter. So I am in opposition to that portion. However, the totality of the bill does gain my support. So thank you, Mr. Chairman.
Further discussion on the bill? If not, Representative Fishbein.
Yes, thank you, Mr. Chairman. Mr. Chairman, I make a motion that we create a consent calendar and that we move SB 5 to that consent calendar.
Is there objection to placing SB 5 on consent? Is there objection? Seeing none, so ordered. Next, I'll entertain a motion to JFS item number 2 on our agenda. It's Senate Bill number 927, LCO number 6385. Motion from Senator Winfield, second from Representative Fishbein. Is there discussion on this item? Senator Winfield?
I was just going to briefly just say what it does. So third-party vendors and contractors would have to have certain specifications that are established by the CJIS as part of the work that they're doing.
Thank you. Representative Howard.
Mr. Chairman, thank you. I intend to support this today. I noticed in the substitute language, we changed the word seek to required, not overly concerning, except and perhaps I'm I'm concerned that a third-party vendor currently in contract with a municipality may now have to meet this standard. And I don't know if that's been discussed, and I just kind of deep into it. I guess my point simply, and I don't necessarily need an answer on that at the moment, but it is a concern. While I voted out today, I expect we'll be following up with CJIS to just make sure that we iron that out, just to ensure that we're not taking a municipality currently in contract who doesn't have a SIP appropriation going forward for a new RMS and, revamping what needs to exist, if I'm making sense there.
Yeah, Representative Howard, that's not my understanding. Certainly, you can follow up with CJIS. The JFS language before us was actually a request of the judicial branch to clean up some technical language.
Okay, perfect. Thank you, Mr. Chairman.
Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I move that we move SB 927, an act concerning the state's criminal justice information system, to the consent calendar.
Is there objection to placing item number 2, SB number 927 on our consent calendar? Is there objection? Seeing none, so ordered. Next, I will entertain a motion to JF Senate Bill number 952, item number 3 on our agenda. I have a motion from Senator Winfield, a second from Senator Flexer. Is there discussion? Senator Winfield.
Yes, thank you, Mr. Chair. This Senate Bill 952 broadens the eligibility for parole, and it would include those who are in our system who are serving long sentences under the age of 25 in that provision.
Discussion on this. Senator Kissel.
Thank you very much. I understand where folks are coming from on this, and we required mandatory review of sentences for youth in response to some recent, when I say recent, I guess in the last decade or so, United States Supreme Court decisions. And so we raised that age to, I believe, 18, especially for those individuals sentenced to long terms. This now proposes to move that process up to age 25. And it essentially begs the question, what do we do with this knowledge that we have that brain development doesn't really finalize until the age of 25? And over the years, we've had presentations. I remember one distinctly from a professor from Dartmouth. She presented to us saying that if you take young people at a certain age and show them a pool of sharks, they'll actually consider jumping in there, wondering if the sharks had recently eaten. Maybe they're not that fast. Whereas when the brain develops, anybody would actually say, no, I'm not jumping into that pool under any circumstances. They're sharks. I'll probably get eaten alive. It was a particularly memorable presentation. So let's assume for the moment that one's brain does not develop to full maturity until age 25. We had the president of the Senate, Senator Looney, come and say this tends to be more with men as opposed to women. You follow that thought through, and now you're going to get into, what is a man, what is a woman, and we can go all that direction. So let's assume the gender issue is there's men and women, male and female, and brain development might be different for both. But I'd like to think, as I'm getting older every day, and we all are, that you learn all the time. Maybe my ability to process things has reached a peak when it turned 25, but I think that every day brings us new experiences, and wisdom tends to be associated with people older in years, as opposed to, is it 18, 19, 20, 21, 25? So maybe the United States Supreme Court down the road will pass some decisions saying they acknowledge and they've done the research to really address the development of one's brain, and they feel that it is required as good policy and under the Constitution to review a person's conviction for what is inherently a very serious crime if you're doing anything above 10 years. But they haven't done that yet. So the argument is maybe this is an anticipation of that. But because we're dealing with essentially adults that have committed very serious crimes, now overlaying this process with a mandatory review up to age because of someone's being up to 25, again, it begs the question, when are we adults under the law and responsible for our actions? And I'm not ready to go down the road that says, well, you're different until you're 25. There's so many things that happen when you're 18 under our laws. There are yet other things like the ability to lawfully consume alcohol at 21. I believe some of our cannabis laws also allow the full utilization of cannabis now in Connecticut at 21. We have young men and women going off to defend this nation at 18 and above. We have gambling that we allow and encourage at 21. And now we want to give an exception, a carve out up to 25. It doesn't make sense to me. It seems like we're doing this just for those who have committed some of the worst crimes that are out there on our books. And while I believe in a second chance society, this is a bridge too far for me. And for those reasons, Mr. Chair, I cannot support this bill at this time. Thank you.
Thank you. Representative Fishman.
Thank you, Mr. Chairman. I agree with everything the senator just shared. I think at some point we have to decide what is the age. What's before us here today is to look at those individuals who were sentenced prior to the age of 25, and they would have to have been sentenced for in excess of 10 years, have to serve that 10 years and essentially 60% of their sentence. Those are very serious crimes under our penal system. It's interesting how the age shifts. So if we say that one who is 24 at the time that they murdered someone did not have the capacity, even though they've been through the criminal justice system and perhaps agreed to a plea bargain, perhaps they decided not to and they went to trial, that decision and the result of that was not part of a fair process, then carry that age through to other things. Raise the age to vote, because certainly those are important decisions also. Nowhere near as important the decision whether or not to take a life. But here, presently under the system that has been created whole cloth by the Board of Pardons and Paroles without our authorization, they can do this presently. So I'm sort of in a quandary here. We hear on one plane, we can do this stuff because we've been empowered under the statutes, but then we need a statute to do this. I too would be somewhat comfortable with 21 because there is some correlatory in our other laws regarding 21. But 25 is a bridge too far. And for that, I'm opposed to what's before us. So thank you, Mr. Chairman.
Senator Winfield.
Thank you, Mr. Chair. And let me just say, I appreciate my colleagues' comments. For the information of the committee, I think many of us know this, but just so that we understand what the bill before us is seeking to do, the 60% that Representative Fishbein talked about is always in effect. If you think about 50 years and 60% of that's at 30 years. And as it goes down back to the minimum of 12 years, we are seeking to take into account the brain science we've learned in the last, I think now 15 plus years or so. And that brain science is not just about what we are capable of learning, it's about how we respond in certain situations. And there's a difference in the ability to respond, particularly in instantaneous situations, high pressure situations, those types of situations. And so I take the analogy to the issue of voting, but voting is different. It takes place over a long period of time. It's a more non-immediate process. And that's why I think that something like that would be different. Here, what we're talking about are situations where young people without the full capacity to rationalize situations have made what is a terrible choice. And that choice may have had a deep impact on the lives of not just that young person, but families, the victim. And we're saying that after a certain period of time, you get the opportunity to potentially be reviewed and get relief. But in that review, we're taking into account what happened. In that review, we're looking at somebody who spent 60% of their sentence. And so while we could argue about whether that's enough time or not, and I think that's a legitimate conversation, this is not a bill that says you committed a crime, you spend no time in prison and you get relief. That's not what this bill is. And I think it's important for us to, I'm not ascribing intention to anything that has been said or will be said, but I think it's important for us to make sure that people who are listening to us understand that that is what this bill does. Thank you, Mr. Chair.
Thank you. Representative Howard.
Thank you, Mr. Chairman. Mr. Chairman, I just want to take a minute for anybody who may be watching this, who's been a victim of a violent crime that is serving a life sentence that has no eligibility for parole. Sex assault victims deal with trauma for their entire lives, and they have no eligibility for parole from that trauma. Individuals whose lives were taken from them by felonious means are serving a life sentence or served a death sentence. Their loved ones, their moms and whatnot are serving a life sentence with no eligibility for parole. So while I can understand the brain science that we hear about, and I'm happy to hear some of the testimony that we heard of individuals who are able to rehabilitate themselves and do well in the community. I think that for me, especially living victims, knowing that an individual is getting out earlier than they may have anticipated creates new trauma. It exacerbates current trauma. And for all the work that I've done with victims throughout my life, I think it's important that I be their voice today, and I will not support this in keeping with that. And I just want to make that statement for the record. Thank you, Mr. Chairman.
Thank you. Representative, I will just know, just in case it wasn't clear from your comment, this does not automatically grant parole to anyone. All this does is provide an eligibility. So, I know we heard testimony with respect to this and other bills this year that sometimes victims and victims' families forgive in different means. And after 30 years, some things change. So someone who committed a crime at the age of 19, by the time they are 49 years old, and might be eligible for parole under this bill, some victims do see and their families do see the ability of those offenders who made a mistake at a young age to re-enter society and to become productive taxpayers. Not everyone, certainly, to your point, but this bill is actually designed at providing flexibility. It's designed at ensuring that in those proper circumstances, someone may petition for parole and may have an opportunity to seek it through our legal process. But to simply cast a broad statement or a broad net and to say that in every instance, every victim would not be in favor of this, I don't think is consistent with the testimony this committee has heard. Further questions or comments on the bill? Further questions or comments on the bill? Representative Dubitsky.
Thank you, Mr. Chairman. We heard some very compelling testimony in favor of this bill during the public hearing. We heard a number of people who had been incarcerated for many years after committing very serious crimes, who had changed their lives while they were in prison. And now that they're out of prison, they are doing what they can to help others reform themselves and help others avoid the bad decisions that they had made when they were younger. So, and I took a lot of that testimony to heart. Clearly, there are people in prison and who have recently been released from prison who could help the cause of preventing violent crime. And we as policymakers need to recognize that we need to do what we can to make sure that the right people are released, that they can help, like some of those who testified. At the same time, we need to sort of make up our mind as to when somebody becomes an adult. As my two ranking members indicated, you know, we're sort of all over the map. Some things we say you're an adult at 18. Some things we say it's 21. Some things we're now saying it's 25 or even 26. I frankly think we need to make a decision. We need to say, at this age, you're an adult. And although it becomes a bright line, and it's sort of, you know, one day you're a minor and the next day you're an adult, we need to have one line as opposed to lots of different lines. In the last couple of years, we've moved this line around for any number of things, from insurance to making permanent decisions with regard to health care and lifestyles. And we've moved it, and there's bills to change that in some instances down to the age of 12 to make very, very significant decisions that could be permanent throughout a person's life, making those decisions at 12 years old. So, you know, what are we going to make it? Let's pick a number. My feeling is 21 is a reasonable number. If this bill changed the date change the age from 18 to 21, I would consider supporting it. But 25, as others have indicated, there are so many things that people do that are life-altering decisions before the age of 25. They go to war, they can drink alcohol, they vote, they can gamble, they can enter contracts, they can buy houses, they can get married, they can have kids. They do all the things that adults do in our society. But we're still going to treat them as children under this bill. I can't do that. I think this is going to 25 is too far for me. I think we need to go to 21 and say, that's it. So I will be voting against this bill. Thank you, Mr. Chairman.
Further questions or comments? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 952 to JFS to the floor. Winfield,
Winfield, yes.
Staffstrom,
Yes.
Lexer, Quinn,
Yes.
Kissel,
No.
Fishbein,
No.
Blumenthal, Callahan,
No.
Conley, Curry,
Yes.
Delaney, Dillon, Doucette,
Yes.
Kubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey,
Yeah.
Paul,
No.
Harding, Hayes,
No.
Howard,
No.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller, O'Day, Osborne,
Yes.
Pavlock D'Amato, Porter, Sampson, Sims, Beach.
Sims,
No.
yes.
Beach?
is a no.
Thank you. Walker and Wilson.
Wilson's, yes.
Thank you. Madam Administrator, we will.
Madam Administrator, and could Dylan be recorded in the affirmative, please?
Thank you, Representative.
My apologies, Mr. Chairman.
Thank you, Representative Dillon. We are going to hold the votes open until 30 minutes after the end of the meeting or 5 o'clock, whichever is later. All right, we will next turn our attention to item number 4 on our agenda, which is Senate Bill number 1023, an act concerning probate court operations. I will entertain a motion for it's a motion to JFS LCO number 6305. I have a motion from Senator Winfield, a second from Senator Kissel. Discussion, if not, Representative Fishbein.
Mr. Chairman, I make a motion that we move SB 1023, an act concerning probate court operations, to the consent calendar.
Is there objection to place this item on consent? Is there objection? Seeing none, so ordered. We will next turn to item number 5, Senate Bill number 1071, an act concerning deceptive or coercive interrogation tactics. I'll entertain a motion for JFS LCO number 6411. I have a motion from Senator Winfield and a second from Representative Sims. Senator Winfield.
Thank you, Mr. Chair. This is the bill we've worked on for several years. What it does is, if there's a custodial interrogation by a law enforcement agent, and they've engaged in deceptive or coercive practices during the interrogation, it limits the evidence of any admission or confession or statement made by the person during that custodial interrogation.
Discussion on this, Senator Kissel.
Thank you very much, Chairman Staffstrom. A question through you, either to yourself or Senator Winfield. It's my understanding at the public hearing that the representatives of the Connecticut Police Chiefs Association had some proposed changes to the underlying bill as it was proposed. And I'm wondering, as this is JFS language, whether those proposed changes were incorporated either in whole or in part.
Thank you, Senator Kissel. My understanding is those changes were at least in large part made in the JFS language.
Thank you, and I appreciate that. I am going to be voting no on this bill today to flag it. I'm not necessarily opposed to the underlying concept. We just went through a discussion as to what's an appropriate age. Currently, the age for a minor is still below 18. Certainly, I'm in agreement that we need to be cognizant of their ability to appreciate their rights. I, on the other hand, still believe that law enforcement does need some latitude to elicit the truth. And it's not always like a direct line, like A line to B. an admission or some sort of evidence and then conviction. This can be information that is extremely valuable in putting together a case. There could be various individuals. And so we get to a point where it's sort of like the fruit of the poisonous tree, right? You can't use that in a court of law. And so that might ultimately mean that justice is not done for the impropriety of something that took place in simply conducting an interview with a minor. So I'm still searching for the balance between protecting the rights of a minor and at the same time not unnecessarily tying the hands of law enforcement. So again, I'll be voting no today in the hopes of trying to reach a happy medium for myself and for the folks that I represent, but I'm not sure that we're there yet. And for that reason, Mr. Chair, I'll be voting no. Thank you, sir.
Further questions or comments, Representative Howard?
Thank you, Mr. Chairman. The term custodial interrogation was used. Was that? That's not referenced in the bill. My understanding is the bill addresses any interrogation, whether custodial or not.
Senator Winfield?
Through you, Mr. Chair, the bill, Representative Howard is correct about what the substitute language does. It does not state custodial interrogation.
Just want to make sure. Sorry. So
Representative?
thank you. So these interrogations are admissions, because an interrogation is just a fancy word for an interview, right? I mean, you're asking somebody questions and you're conversing with them to investigate a crime, or I suppose you wouldn't. I don't generally use the word interrogation when you're talking to a victim or a witness, but again, an interview. So I look through this and I do have some concerns, even as it relates to the adults. Now, certainly when a law enforcement official unreasonably deprives a person being interrogated of physical or mental health needs that knew or should have been known, and that can be shown, I would argue that by current case law is already inadmissible because the confession was unduly coerced. I think it's important to note too that unlike some other states, actually unlike many other states, our state requires police officers to wear their body cams during every interaction with the public. So when they're conducting these interrogations, the entirety of it should be audio and video recorded, which would allow a court to make a determination if anything that happened in that interrogation was unduly coercive, and therefore the interview or the interrogation should not be admissible. And sometimes interrogations take place where you have an undercover working. And sometimes, like in a gang unit, perhaps a murder for hire situation where you have an undercover agent or an undercover officer working on that. There may be times when there's a threat and use of physical force upon another person. That sits at the impetus of the investigation. That's what it's based upon. So to now create another pretrial opportunity for a defendant to have fun with this new language, should this pass, I think is a concern for law enforcement. Relevant to the juveniles, I'm in agreement somewhat that you have to change the rules a little bit when you're talking with a child mind. I get that. However, one thing that's important to know too is we've heard from advocates and professionals and experts that there's new training in law enforcement in the way of interrogations, where officers who were previously trained in these ways are being now trained in this new method that they say has much better success rates. I don't know that training has taken effect in Connecticut at this point. I'll offer that if you happen to know that.
Senator Winfield?
Thank you, Mr. Chair. And I don't know for sure what's been implemented in Connecticut in terms of training. I will just take this opportunity. I tried to grab the mic before you started to clarify. The bill does talk about custodial interrogations. What I was saying was that in terms of the definitional part of the bill, there is no custodial interrogation. I would also say that the points you made are real in terms of what happens with body cameras. I don't see that as a reason not to do what's in this bill as well. We know that body cameras aren't always turned on when they're supposed to be. We've seen some of that. There are times when there's a malfunction. There are all kinds of reasons why the body camera might not be in play. I don't think any of those things prevent us from making sure what we want to happen, particularly as this bill relates to children, is in place through you, Mr. Chair.
Representative Howard.
Thank you. I appreciate going back to the custodial thing, but I would just say that if the representation is designed for custodial interrogations, I mean, interrogations take place without custody every day, every single day, all the time. You do an interrogation on a sidewalk. For purposes of Miranda, the courts have ruled that a car stop is not custody for purposes of Miranda in an interview. Perhaps that may be an opportunity. So it does seem to me that the wording as it exists is all interrogations. But going back to that training, we've trained law enforcement officers a certain way to do interview and interrogation for a long time. And if there's new training, perhaps getting that new training rolled out to officers prior to changing the rules, for lack of a better term, may be in the best interest of public safety and in criminal investigations for the state. I'd also say that, communicating false facts about evidence that were known to the law enforcement agency or the official or should have been known is also a little bit difficult. Again, do we have a lot of juveniles that are involved in gangs and narcotics in this state? I don't really know. I don't work in the cities. I'm not exactly sure. We don't necessarily have that in certain areas where I work. But if those things are existing and you have an undercover officer who lies about his office, lies about whether or not he's a cop. When you're working undercover, people ask it all the time, are you a cop? It's the first thing you say no. My concern is, a subsequent conversation that takes place in that capacity may be, unduly figured out to be coercive tactics. I think that when you communicate false statements or misrepresentations of the law to a child, you're out of bounds. I agree with that part. I think communicating misleading promises of leniency to a child is out of bounds. I think I'm in agreement with that particular part. Then I go back to adults with the last sections here. And it seems to me that we're putting a presumption that a confession shall be deemed involuntary and inadmissible unless the state proves by clear and convincing evidence that it was voluntary and not induced by use of deceptive tactics. So we're putting the onus on the state, whereas in the past, my understanding was it was a preponderance of the evidence. So in those interrogations that are taken from adults, now we're upping the ante of what the state needs to prove to get those confessions to be admissible. Am I right in that, Mr. Chairman?
Representative, I'm going to step in just for a second here because I think we've gotten a little afield of what actually is a custodial interrogation. I would direct your attention back to Congen Stat 54-103 and 1, which in fact provide in our statute a definition of what is a custodial interrogation. And that's an interrogation while a person is in custody, and custody means the person has been placed under formal arrest or there was a restraint on the person's freedom of movement of the degree associated with a formal arrest, and a reasonable person in view of all the circumstances would have believed he or she was not free to leave. So this is not a casual conversation. This is, in most every instance, the formal interview in the police precinct as defined under our law. So if you want to reframe your question with that in mind, feel free.
Well, I appreciate what you're saying, Mike. So let me go back, and I'm in full agreement with you of what custodial interrogation is, and that the custodial interrogation is defined as you pointed out. However, the bill, as I see it, with the S language before us, it says, as used in this section, deceptive or coercive tactics includes but is not limited to any tactic that, and it goes on, the person being interrogated And section 2, upon the person being interrogated. Nowhere, I appreciate your definition of custodial interrogation. I'm in full agreement of that and what custody means. As I understand this bill, it would apply to interrogations that are non-custodial. So in other words, if you're stopped to talk to an individual on the side of the road who is free to leave at any time, but you're questioning them about a case that they may be a suspect in, that's not custody. And under this law, under this bill, that interrogation would fall into this absent custody, wouldn't it?
No, the only issue is the confession and whether that confession is admissible, which specifically applies only to custodial interrogations, line 30 of the bill.
Line 30. You say line 30, the S language?
Yes, sir.
Perhaps you have updated less language. I don't see that in the S language that I have.
Are you working off of LCO number 6411?
Yes, and you're in line 3030.
During a custodial interrogation by a law enforcement agency, official, or their agent.
Okay. All right, I appreciate it. Thank you for that clarification. And then, so my last
Are
one.
there further questions on the bill? You have further questions on the bill?
Yes, one more. Just going back to am I correct that we are stepping up the burden of proof that the state has to prove from preponderance of the evidence to clear and convincing, making it more difficult for the state to overcome that to get a confession in?
Nope, we're not changing the burden of proof through this bill. All we are doing is actually still providing a way that if one of these deceptive practices are used, that there still could be a way that information could be admitted, as long as the factors there are shown by clear and convincing evidence, but the burden of proof remains the same on the underlying charge.
Thank you, Mr. Speaker, Mr. Chairman.
Further questions or comments on the bill? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 1071 JFS with LCO number 6411 Winfield,
Winfield, yes.
Staffstrom,
Yes.
Flexer, Quinn, Kissel.
No.
Fishbein.
No.
Blumenthal. Callahan,
No.
Conley. Curry,
Yes.
Delaney,
Representative Delaney votes yes.
Dillon. Doucette,
Yes.
Drubitsky,
No.
Elliott, Gaston. Gilchrist, Godfrey,
Yes.
Hall,
No.
Harding, Hayes,
No.
Howard,
No.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller, O'Day,
O'Day, no.
Osborne,
Osborne, yes.
Havelock D'Amato, Porter, Sampson, Sims,
Sims in the affirmative.
Beach,
No.
Walker, Wilson,
Wilson's yes.
and Pavlock D'Amato.
Pavlock D'Amato votes no.
Thank you.
All right, we will move on to item number 6 on our agenda, Senate Bill number 1072, an act concerning revisions to the Common Interest Ownership Act. The motion is a JF. Motion from Senator Winfield, second from Senator Kissel. Representative Fishbein?
Mr. Chairman, I make a motion that we move SB 1072, an act concerning revisions to the Common Interest Ownership Act to the consent calendar.
Is there objection? Seeing none, so ordered. Number 7, Senate Bill number 1119, an act concerning business registrations with the Office of the Secretary of State. The motion is a JFS, LCO number 6311. Motion from Senator Kissel, second from Senator Winfield. Discussion. Representative Fishbein.
Mr. Chairman, I make a motion that we move SB 1119, an act concerning business registrations with the Office of the Secretary of State to the consent calendar.
Is there discussion? Is there discussion? Seeing no, sorry, I should say, is there objection? Seeing none, so ordered. Next, we'll move to number 8, Senate Bill number 1134, an act concerning the recruitment of law school students for apprentice prosecutor positions. The motion is a JF. The motion is from Senator Winfield, second by Senator Kissel. Is there discussion on this, Representative Drubitsky?
Thank you, Mr. Chairman. I just want to make sure that, and I believe I know the answer to this, but I just want to confirm that allowing law students to be prosecutors will not give them the discretion to prosecute cases and to decide which cases get prosecuted. Those decisions will still be made by career prosecutors. Is that correct through you? Mr.
Yes, and through the normal chain of command within the division. Frankly, what this bill is designed to do is allow for recruitment into law schools, allow law students to begin to start to work in the prosecutor's office before they have been formally admitted to the bar. And so those individuals will not actually be allowed to appear before a judge because they're not admitted to the bar yet, but will essentially receive training, apprenticeship type training, like a summer associate or a law clerk, in the hopes of increasing the recruiting pipeline, as we do have a significant shortage and pipeline of folks wanting to be prosecutors.
Thank you, Mr. Chairman.
Further discussion on this? If not, Representative Fishbein.
Mr. Chairman, I make a motion that we move SB 1134, an act concerning the recruitment of law school students for apprentice prosecutor positions to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. 9, Senate Bill number 1193, an act concerning the reviser's technical corrections to the general statutes. I'll entertain a motion for JFS. The JFS is LCO 6349. Motion from Senator Winfield, second from Senator Kissel. This is our most substantive bill of the year, our annual reviser's technical bill, but it makes our LCO attorneys very happy. So if you don't want to vote for this one, take it up with them. Representative Fishbein.
Thank you, Mr. Chairman. Being one that has read the tech bill and is happy with it, I make a motion that we move SB 1193, an act concerning the reviser's technical corrections to the general statutes to the consent calendar.
Is there objection? Is there objection? Seeing none, so ordered. Number 10, Senate Bill number 1194, an act relieving certain registrants of the requirement of the sex offense registry and clarifying registration requirements for persons transferred into this state and who reside in congregate care settings. I'll entertain a motion for a JF. Motion from Senator Kissel. I'm sorry, motion from Senator Winfield, second from Senator Kissel. Is there discussion on this bill? Is there discussion? Seeing Representative Fishbein?
Thank you, Mr. Chairman. Mr. Chairman, I think a portion of this bill rights a injustice that was done to certain individuals who did not know at the time that they were convicted or they agreed to a charge that there would be, well, they didn't know there'd be an additional penalty. And post that conviction, the legislature said anybody who had been convicted of certain things was required to do things that they weren't previously required to do. And that is not due process. That is not equal protection. So I do recognize and I am in support of what's before us to right that wrong that this body did at one point and approved by the governor at that time. So thank you, Mr. Chairman.
Further discussion on this bill? Further discussion? If not, Representative Fishman.
Yes, Mr. Chairman, I move that we move SB 1194, an act relieving certain registrants of the requirements of the sex offense registry and clarifying registration requirements for persons transferred into this state and who reside in congregate care settings to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. Number 11, Senate Bill number 1195, an act establishing secondary traffic violations. I'll entertain a motion for JFS. Hold on, I want to make sure we get this. This is a motion for JFS. The LCO number is 6455. 6455. I have a motion from Representative Porter and a second from Senator Winfield. Is Senator Kissel?
Thank you very much, Mr. Chairman. We had a proposal regarding this in past years as well. But the group that was charged with examining this issue went back and I want to acknowledge, I thought through the public hearing that they presented a really good case. They really did a lot of hard work. Reasonable people can disagree as to what is important regarding a secondary traffic stop. I had made a request regarding the issue regarding rear lights. Those include tail lights and brake lights. And my concern was that's just a functioning part of the car that's very important that the driver would not necessarily see as out, but for the traffic stop. And while there was testimony and anecdotal information regarding good Samaritans out there that would say, hey, you know, pull over, your lights are out, or just a heads up, your lights are out. I think those are the lucky people that have somebody step in and alert them. But law enforcement can provide a valuable role in those situations as well. And again, I would say probably all of us, and if not all of us, the vast majority of us drive every day. And just seeing the person in front of you's lights is critical to driving safely. The chairs were kind enough to accommodate that concern, and that was incorporated in this most recent S language. Now, above and beyond that, what I gleaned from the public hearing was that if you take the law enforcement people hours that are used in addressing these issues and redirect them in other areas of law enforcement, that the eventuality of getting the serious bad actors out there goes up. One can debate that as well, and I get it. But I just think that the case was made in my book regarding this initiative. And I think that, you know, especially as it's harder and harder to recruit law enforcement, I think that efficient utilization of the men and women who are that thin blue line that protect each and every one of us is better utilized in trying to go after the bad actors as opposed to getting bogged down with these secondary traffic stops. I know folks may disagree with that, but for this senator's part, I think the case was made. I'd like to actually thank my friend and former colleague, the former House Chairman of Appropriations, Bill Dyson, too, that came and testified for his leadership of the group that studied this. And for those reasons, Chairman Staffstrom, I'm happy to support the bill at this time. Thank you.
Thank you, Senator. And just before we go on, I just want to echo your thanks. Certainly, this is a proposal that has come to us from a task force that was made up of folks from the community, from law enforcement, from police chiefs. And this was a consensus recommendation that they came to this committee with. As you know, in the S language, we are, I would say, rejecting one piece of their recommendation, such as our prerogative as a committee. But I think the fact that we're adopting, hopefully adopting most of it, shows the value that we place in those recommendations that we get from the groups we put together that worked extensively on this. So thank you for recognizing that, Senator Kissel. Further discussion on this bill, Representative Howard?
Thank you, Mr. Chairman. Just, and I'm not in favor of the bill, as you well know, and I'll vote against it, and I won't belabor the point, except to make a few points here. But as I understand section 1, and bear with me, because I just got this S language 2. This provision shall not prohibit enforcement of secondary violation by automated enforcement. That would include license plate readers, correct?
That's my understanding.
Okay. So that part, understanding that there's parts of this that I would argue are de facto secondary violations already. Failure to renew your operator's license, failure to notify the DMV of change of address, failure to carry your operator license on your person. I don't know how these could be primary violations.
Was that a question?
Sure, I'll pose it as a question. Why are we making these secondary violations when they are effectively already secondary violations?
I agree with you that they are in fact almost de facto secondary violations and unprosecutable. I think the task that was put to this task force was to look at those types of violations and make sure that we are codifying that practice into statute. And that's essentially what we're doing here.
Understood. I would say also, Mr. Chairman, about the failure to renew after the expiration of a suspension. I would say that about horns. These are all de facto secondary violations. And I think, to your point, don't really change what's actually going on. I have no objection to those. I do fear that this will send a message that we want to limit traffic stops, which I know is not the intent. And I want to be clear about that. At least it's not. I don't believe that that's the intent. I do have some safety concerns. For example, if somebody's driving around with dark tint and one headlight, that makes it difficult to see. Having driven vehicles that have tint on them in the past in different assignments that I had, it is more difficult, especially in not well-lit areas, to see out of a vehicle when there's tint on the windows. And as a result, you're creating a safety hazard on our roads. And we're doing that at a time when we've had, significant pedestrian deaths in this state relevant to traffic crashes. And I think that that's, concerning to me. The other question I had, and perhaps you would know, I believe it's section 19 now. As I understand that, it looks like the intent was to make a secondary violation relevant to mirrors. But as I read that particular section in that statute, I think that statute also addresses a moving violation, whereas somebody in a vehicle that has a vehicle that's going slow and has a vehicle coming from behind has to move over. It's a vehicle that's not a motor vehicle. I'd imagine that'd be like a bicycle or something similar to that when they're in the middle of the road. And this requires them not only to have a mirror to be able to see behind them when they're otherwise obstructed, but also upon the approach of those other vehicles to actually move. So am I correct that this would prevent a police officer from making that a primary violation if somebody failed to move to the right side of the center? Because I read the beginning in line 869, any person operating such a vehicle shall make observations for the approach of vehicles from the rear end. When so approached, shall drive to the right of the center line of the traveled way as promptly as safety will permit, giving the vehicle approach from the rear opportunity to pass in safety. And a violation is now a secondary violation. So somebody can't be stopped for that moving violation.
Yeah, but I don't believe this is the emergency vehicle provision. I would have to go back and look at the rest of.
No, I'm in agreement, Mr. Chairman.
Okay.
It's not the emergency vehicle. That would be 14286. I think this.
Right.
I think this references a vehicle that's not a motor vehicle. That is, perhaps a bicycle that has some sort of boxes or something on the back delivering pizza or something of that nature where they can't see behind them. This requires them to have a mirror to observe traffic coming behind them, and when they see traffic, to move to the right so the oncoming vehicle has opportunity to safely pass without creating a hazard. So this appears to make that a secondary violation. See, and the reason I bring it up is because I look through and it seems to me that the intent of this was to take certain equipment violations or administrative violations and make those secondary violations. But this one stood out to me because it appears to be a moving violation. And it could very well be that this is addressed somewhere else in the statute. I didn't see it.
Yeah, I guess we can certainly look into that a little bit further as this moves on. I'm not sure how many pizza delivery bicycles are still left in the state, but
You should come down to Mystic.
we'll take a
We have a great
look
pizza place there. They made
down
a
at
movie out of it.
Mystic. You know, but I think to your broader point, Representative, certainly on window tint and some of the other violations in here, you know, and I suppose reasonable minds could differ, but I don't disagree with you that there are far too many folks speeding, driving recklessly, running through stoplights, committing serious, or I should say, potentially very dangerous activity on our roads. Certainly I see it in my town and I'm sure others do as well. And frankly, part of the intent of this bill, as the good Senate ranking member alluded to, is to make sure that or to encourage a police officer to stop that speeding vehicle or that car that goes through a red light, as opposed to what I would say is wasting their time by pulling someone over for you know, a reflector that is out or a window tint that they may believe is too full. It doesn't take long to sit there and watch somebody pull through that actually should be pulled over. And so that's precisely what this bill is designed to do, I think, is alleviate your concern and mine about deploying police resources in the proper manner.
Thank you, Mr. Chairman. I appreciate that. With all due respect to the leadership of this committee, I do have to push back a little because I just don't believe that there are police officers in this state that are not getting around to speed enforcement or traffic light enforcement or distracted driving enforcement. Some of the main reasons for these accidents because they're just too tied up and focusing their attention on these low level violations. I just don't believe that that's what's happening. But what I do know is that there has been a 65% reduction in our state police vehicle stops from 2019 to 2022, about a 40% reduction in those stops statewide by law enforcement. And again, not just pedestrian traffic, but traffic crashes, death resulting, have seen record numbers. As you all know, and I've referenced it before, there is data from a study that was done by NHTSA and the DOJ, where over a 29-week period, they increased traffic stops for a variety of reasons, whether they were moving violations, they were several, low-level violations such as we have here. And during that time in those target cities measured against a control, gun seizures went up by 65%. And gun crimes declined in the target area by 49% with the increased patrol. The traffic citations went up 24%. The initiated activity went up 28%. But it wasn't just that. Violent crime down 10%, property crime down 12%, and most notably, traffic crashes a 21% reduction. Because the reality is, when you drive down a highway or a road to get to where you're going, you see a person pulled over. Unless that person happened to pass you at 95 miles an hour a minute or two ago, you don't know why they're stopped. You don't know if they're stopped for an out headlight or a busted windshield or texting and driving or driving drunk, whatever. You have no idea. You just know that the police officers are out doing car stops. And that, in my opinion, and not just my opinion, that's backed up by this data from the DDAX historical review, that that is the case. And it will lead, increased traffic crashes, increased traffic stops will lead to a decrease in traffic crashes and other violent crimes. So I just don't think that at this time, with what we've seen in our state, that we send a message to our law enforcement that we want any reduction in traffic stops. And I just don't believe. And I talked to a lot of police officers. I polled a lot of police officers on this particular bill, and not one has told me, Greg, I just can't get around to stopping the speeders because I'm busy chasing around out plate lights or out headlights, as the case may be here. So I just don't think the timing of this particular. While I appreciate the intent, I appreciate the work that went into it, I just don't think the timing is appropriate, and I'll be voting no today. Thank you, Mr. Chairman.
Further questions or comments on the bill? Further questions or comments? Representative Callahan?
Just a brief comment, Mr. Chair, as my good friend Representative Howard just so eloquently stated, I don't think this is the right time to be lowering the bar on safety on our roads when we're seeing the statistics that he just mentioned, and I will not be supporting the bill.
Further questions or comments? Further questions or comments? Representative?
Thank you, Mr. Chairman. Just want to agree with the two previous speakers. I do think this is an important tool for our law enforcement to be able to use to take illegal guns off our streets, and also drug seizures happen. I don't think we should be supporting anything that further inhibits our police from stopping these particular drivers. I do think it's an important tool, and it helps keep the rest of us safe. And I think that passage of this bill would, in fact, endanger us further. So for all those reasons, I'll be voting no today. Thank you.
Further questions or comments? Further questions, comments? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 1195. JFS it to the floor with LCO 6455. Winfield,
Winfield, yes.
Staffstrom,
Yes.
Flexer, Quinn,
No.
Kissel,
Yeah.
Fishbein,
No.
Blumenthal, Callahan,
No.
Conley, Curry,
Yes.
Delaney,
Yes.
Dillon, Doucette,
Yes.
Dubitsky,
No.
Elliott, Gaston, Gilchrist, Godfrey,
Yes.
Paul,
No.
Harding, Hayes,
No.
Howard,
No.
Johnson,
Yes.
Khan,
Hi, Representative Khan votes yes.
Labriola, Lesser, Mar,
Yes.
Miller,
Yes.
O'Day,
Representative O'Day votes no.
Osborne,
Osborne votes yes.
Havelock D'Amato, Porter, Sampson, Sims,
Representative Sims votes yes.
Beach,
No.
Walker, and Wilson.
Wilson votes yes.
We will next move to item number 12 on our agenda, and Senate Bill number 1230, an act expanding access to public defender services. It's a JF. Motion from Senator Winfield, second from Senator Kissel. Is there discussion on this bill? Is there discussion on this bill? Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I move that we move SB 1230, an act expanding access to public defender services, to the consent calendar.
Is there objection to place this item on consent? Seeing none, so ordered. Number 13, House Joint Resolution number 34, resolution concerning certain witchcraft convictions in Colonial Connecticut. It's a motion for a JF.
Second.
I have a motion from Senator Winfield, a second from Senator Kissel. Is there discussion on this item? Senator Kissel.
Thank you very much, Chairman Staffstrom. Well, as the kid who grew up in Windsor, first English settlement in Connecticut, 1633, I was originally concerned about this bill because I'm just wondering about the path that we're striking here, and whether we have to go back in our state's history and try to right every wrong, which would just keep us super busy when we have a lot of pressing matters. But on this particular one, this isn't the first time this proposal has come before us, and I gave it a lot of thought. And I want to thank all the folks that came and testified regarding this. I was lucky enough to learn about witchcraft recently, as far as how did we get to this part in Connecticut? And as I had stated during the public hearing, I've been to Salem almost every year, probably for the last 25 and 30 years, but this is about Connecticut. And so I had recommended to a lot of the people that came and testified, there's an excellent book out there. It's directed towards probably kids in middle and high school, called The Witch of Blackbird Pond. It's about our colonial Connecticut. It gives you a glimpse as to the crazy mob mentality that can overtake people when they are afflicted with problems in their community and going after an individual that may be looked at as outside of the norm or outside the closed community. And so I absolutely recommend it. It takes place primarily in the town of Weathersfield, not far from here. It's a great book. An adult can read it, not just kids. So The Witch of Blackbird Pond. Witchcraft. Europeans were very much involved in this. And that's probably from the 1400s on. But it really sort of came into its full in the English speaking world. And I would lay, if we're going to say blame, I'm going to lay the blame at the feet of, and this is an irony, King James VI of Scotland. And for folks that are quasi-historians like I am with one of my degrees is a history degree from UConn. In 1590, he was coming back from Denmark, where he took a ship to get his wife, and there were huge storms. And as he got back to Scotland, it became very apparent that Queen Elizabeth was getting old and she had no heir. And so going through the lineage, it turned out that it appeared that James VI of Scotland was going to ascend to the throne of Great Britain and in England upon Elizabeth's death. And so they had to swallow that. That was a big deal. It wasn't a foregone conclusion. Part of what he did is, as what we see so often in history, is you get support by picking on someone outside the approved group and sort of scapegoating them or targeting them or proving virtue signaling back in their day. He wrote a pamphlet on the dangers of witchcraft, based a lot on European models, booklets that were out there, and primarily in the little German principalities, with a lot of the notions that they had. And he targeted several individuals, but the primary one that we know of was a woman named Agnes Sampson. And they looked for the mark on her body, and it was a torturous ordeal. And in January of 1591, they strangled her and then put her, torched her and set her on fire. In excess of 1,500 purported witches were then killed in Scotland over the next 100 years. By showing that he could stand for the realm, he was accepted as king of all of Great Britain, then moved down to London. The irony is that the King James Bible was also at his charge. But I think much of his acceptance was the fact that he was unafraid of the devil as he walked through the lands. Also, don't forget that at the change between Elizabeth and James, there was that friction between Catholicism and Protestantism. John Knox up in Scotland, very puritanical in their ways. Eventually, Great Britain would suffer through the English Civil Wars in between Charles I and Charles II. And it's also sort of like a bookend, because it was really Queen Anne in the early 1700s that put an end to accepting testimony as against a witch. And we're all sort of familiar with that ludicrous notion that if you throw someone accused of witchcraft into a river or a pond or something like that, if they sank, they were innocent. If they floated, they were guilty. So you can't win in that situation either. Here in Connecticut, we had part of that English craze. The witchcraft trials in Salem were 1692, and nobody was put on, torched or put on fire. They were hung. There was one gentleman that had boulders put on him, and he was so defiant that he kept saying more weight. And the weird thing about these trials, if you didn't know, is that if you accepted and said, I am a witch, they'd let you off the hook in most instances and just sentence you to a long period of time, but they wouldn't put you to death. It was the ones that stridently said, I am not a witch. quite often there were land grabs, there were people ostracized from society and things like that. In the testimony regarding the ones that took place in Connecticut, we had one where a gentleman was shot on a town green by an errant musket, and then the witch was accused 3 years later. In the town that I grew up, Windsor, and again, we assert that we're the first English settlement in this running battle with Wethersfield, but there were witches that were found guilty in Windsor, which was much larger than it is now. Thus, you have East Windsor, South Windsor, Windsor Locks. And a lot of folks don't know that much of north central Connecticut, Enfield, Suffield, the towns that I currently represent were part of the Massachusetts Bay Colony until 1751. So even parts of Connecticut back in these colonial days were not even part of Connecticut, it was part of Massachusetts. I came to the conclusion, and I want to thank the people that testified, especially folks from, if not my part of Windsor, that I still have the honor of representing Windsor and Pequannock and Rainbow, north of the Farmington River, which is such a crazy honor, representing part of the town for 31 years now that you grew up in. But there was testimony in particular from a young lady, who's the granddaughter of John Carmen, a friend of mine. You might be familiar with Carmen Funeral Parlors, but she made a good case that she said there's a strand here of sort of male domination of women, and that a lot of, the witches were women. This is a particular valid point because Knox back in Scotland rather, seemed very much against women in society and wanted to reassert male domination. So you see that theme running through the witchcraft trials of essentially the 1600s. Far worse in Scotland and England than America, but certainly not a wonderful chapter in our history. So by this resolution, even though there may be problems with it, because of the fact that it took place when we were all, as a state, part of Great Britain and not even an independent nation for many years to come, it was a wrong. And no matter how you believe about magic and the occult and things like that, and I consider myself a spiritual person. I believe in miracles. I'm a Christian. I believe in Jesus, but everybody's up to their own beliefs. And being an atheist or a pure science, although the greatest scientists tend to believe in religion of some sort, according to my studies. No matter where you fall on that, to say that these individuals caused harm to others through casting spells or using puppets, or what we would probably analogize to voodoo dolls, potions and things like that, when, for example, in Salem, it's just writhing young women, preteens and teenagers, that would be sufficient information for a jury to convict someone that would ultimately result in their hanging is just amazing. We all know that a great play was written in light of the hunting down of communists in America in the 50s, the McCarthy hearings, the Crucible by Arthur Miller. And we just use it like common now to say that's a witch hunt. That's a term that's used often, but it's not a great part of our history. It's if you go and walk between this building and the Capitol and that walkway where they have the different periods, if you look on the mural right here, one floor down, there's a picture of a hanging witch in the colonial period. It's part of our history. And today is a day that we get to right that wrong in some way, sense, or form. You're probably going to think I'm a little crazy. I think I'm sort of doing a service by voting yes today to sort of, it's my way of sort of saying to the spirits, you can rest a little easier now. I don't know what happens when we pass from this mortal veil, that's for sure. But I think that it's a tragic chapter in our history. It's one that we have to acknowledge. I don't agree with the wiping out of history. I think we should learn from it and study it and acknowledge it. But tearing down statues and just blanking out pages and chapters and pretending it did not exist, that's wrong. But acknowledging what we now in retrospect believe to be wrong And you have to understand, they thought in many instances they were doing right. Was it a land grab? Was it something bad in some instances? Absolutely. Absolutely. There are bad people in every walk of life and every time of history. But there were also true believers that felt that they were afraid of the devil and they were afraid of evil. And this is how they acted out. The other day, a power went out in my home and it's like a little spooky. And I was joking with my teenage son saying, imagine just living in a world where there's no electricity, nothing. And, it could be scary. And yeah, but also the amount of scientific discovery at that time was lacking as well. So it's a long-winded answer and statement. You guys all are used to me, so it shouldn't be no surprise to anybody here in this room or in this building. But it took me a while to get to this part. My friend and colleague of years past, former Senator Andrew Rohraback, now Judge Rohraback, an ancestor of the Rohraback era, another mural that we see in the walkway, put forward a similar bill, and it never even got out of committee, I believe. But this is one that can actually do good, and for that reason, Mr. Chair, I'm happy to support it at this time. Thank you, sir.
Thank you, Senator Kissel. Representative Fishman?
Thank you, Mr. Chairman. What's before us is actually procedurally improper. It's not only procedurally, but on human relations, it's improper. When one asks for an apology, one asks the individual who did them harm. Here, this resolution before us says that the state of Connecticut apologizes. The state of Connecticut had absolutely nothing to do with this. So if anything, the individuals, we were Great Britain. We were a colony at the time of this. You really wanted to do something, you go to Great Britain. You ask them to apologize. So I don't know why, other than to say we did something, this would even be before us. Does absolutely nothing. It's like somebody stealing a car and asking the neighbor to apologize. It had nothing to do with it. I know that in 2012, this was sought. And as the good ranking member of the Senate mentions, it didn't make it out of committee. What we have before us here today is really no better. Spent a lot of time this weekend looking at the histories of many of these individuals. Not all of them were even convicted of witchcraft. Whoever put this together should have done their homework. And yet, what we have before us is a resolution apologizing for convictions of some individuals. Resolution doesn't say what they were convicted of. That's very suspect in and of itself. But when you look into it, they weren't all convicted of witchcraft. There's a portion that has to do with individuals who allegedly may have been charged with that, among with other things, and were exonerated. There's one undefined and unidentified individual in line 31. So we're apologizing expressly in the language to an unknown person in Saybrook in 1659. Who is that? Who are we apologizing to? That's the language before us. I won't continue to peel back the onion. We'll save it after this overture, which has no power at all, may be addressed in another forum. I will note that all of these people are, to my knowledge, deceased, and there is no ability to unpack or pardon something that happened with somebody who has already passed. So once again, if someone was looking to have this language have any effect upon a body that actually did absolutely nothing, you'd have to change the enabling statutes to provide as such. So, you know, perhaps someone will go to Great Britain and file whatever needs to be filed in Great Britain because they're the ones that were involved. 'Cause I believe Connecticut didn't join the colonies until 1788, almost 100 years after the stuff that's complained of in the resolution. So I intend to vote against. It may be a nice idea, a nice gesture. It's sort of like a Valentine card. But that's all that we have before us. So thank you, Mr. Chairman.
Representative Trubisky.
Thank you, Mr. Chairman. I agree that this bill is in the wrong place and it's asking for the wrong type of relief. It also, the testimony that we got was not the type of testimony that one would expect when we're being asked to exonerate somebody for a crime. I was in the public hearing. I was in and out of several different meetings at the same time, but I think I was in the public hearing on this bill for perhaps 10 minutes. I was watching it on remotely for the rest of the time, but I actually was physically in the room for about 10 minutes. I think I asked one question. I asked one of the proponents of the bill, one of the people testifying, if there was any evidence that the people they're asking to be exonerated were innocent of the crimes that they were convicted of. And by asking that question, I was then the subject of probably a dozen or more newspaper articles across the country, from San Francisco to Texas to several in Connecticut, all with the same sort of baseline that I was a rube because I thought that witchcraft was real, and therefore I needed some evidence that these people were not witches. Well, that ain't how it works. When we are asked to exonerate somebody for a crime, the legislature is sitting sort of in a judicial role. We're not making policy. We're not really passing laws. We're making a resolution that either the person didn't do what they're accused of, or because of the passage of time, that crime should no longer be a crime. So, for example, a number of years ago, I was asked, along with some of the other representatives and senators in my area, were asked to sign on to a resolution in the state of Virginia, asking the Virginia legislature to exonerate one of the John Brown's raiders. John Brown was an abolitionist who, with a group of Northerners, took over an armory down in Harper's Ferry, Virginia, during the Civil War, and a number of people were killed. They were trying to seize the weapons for the fight against slavery. one of John Brown's lieutenants, essentially, was captured and charged with murder and charged with inciting slaves to riot, and was ultimately hanged. So we were asked to sign on to this resolution to exonerate him. And we were presented with and were required to present to the Virginia legislature a ton of evidence with regard to the crime for which this gentleman was convicted. One of the crimes that he was exonerated of was murder. So the only crime that he was actually convicted of was inciting slaves to riot. So I was certainly willing to sign on to that, and I participated in petitioning the Virginia legislature to exonerate this gentleman hundreds of years after his death for inciting slaves to riot. My guess is if I had been there, I perhaps would have incited slaves to riot as well. But I wanted to make sure that I knew, and the Virginia legislature insisted on knowing, what the evidence was that this person had either committed the crimes or not. We had to present the trial record. We had to present evidence of the testimony, evidence of the crimes committed and exonerated. I needed, and the Virginia legislature needed the evidence. So when somebody comes and says, we want to mass exonerate all these people who were accused of so-called witchcraft, I asked, where's the evidence? My understanding is many of these people were not even accused of actual witchcraft. They were accused of things such as murder, consortium with the devil, and other crimes that did not include the actual crime of witchcraft. I don't know which person is accused of which crime and which ones they may or may not have committed. That's why I wanted to see the evidence. Without that evidence, how do we know what we are exonerating these people of? Are we being led to believe that none of those things are crimes or should be crimes? If somebody committed murder and also committed a crime that is considered witchcraft or consorting with the devil, should that person receive exoneration from this legislature hundreds of years later? I would think not. Murder is murder. Do people believe that there is no devil anymore? Well, people who believe in God typically believe there's a devil. Is it no longer a crime to consort with the devil? Well, I guess it's no longer a crime in Connecticut to do that, but does that mean that it wasn't a crime back then? You know, all these things need to be sorted out before this legislature could say that these people all deserve exoneration from us. Put on top of that the fact that there was no Connecticut legislature at the time. All those people were British subjects. Well, we're going to apologize for what Great Britain did hundreds of, excuse me, hundreds of years ago. It doesn't make any sense. So, I'm going to vote against this. I, have all the sympathy in the world for the distant heirs of those who were convicted of witchcraft. But who are they? Which people were convicted of which things? We didn't get that evidence. And before I could support any bill that would exonerate these people, I would need to know what they were accused of and whether they actually committed those crimes. Apparently, there were a number of deaths involved in a number of these accusations. Did they murder somebody? Are we exonerating them for the murder, or just for the accusation that that murder was conducted under the auspices of witchcraft? We don't know. And it would be silly for us to exonerate these people without knowing. Thank you, Mr. Chairman.
Thank you. I just want to make sure the committee is clear on this bill, and maybe I didn't do a great job of explaining it. We're not exonerating anyone under this resolution. As has been pointed out, we don't have the ability to do that. These were convictions under the then colony of Connecticut and the colony of New Haven. And so this resolution doesn't exonerate anyone. What it is an expression of sympathy and an acknowledgement of trauma that was inflicted on certain individuals who lived within the territorial limits of what are now Connecticut. And it's an expression of sympathy towards the descendants of those individuals, some of whom continue to live here in Connecticut and came and testified before this committee. This resolution is an acknowledgement, as Senator Kissel noted, of mob mentality, of folks who were punished for nonconformity, folks who were the victim of misogyny, were ridiculed for adultery, and generally have been victimized as a result of conduct that in large measure would not be considered criminal in today's state of Connecticut. I think we need to just be very careful, because we're right. We are not exonerating. This is not a trial. We're not granting a right to sue. This is not going to the claims commissioner or anything of that nature. This is merely an expression of sympathy and acknowledging a part of our history. It is also, in that vein, not an erasure of our history. It is acknowledging a part of Connecticut history. Be that negative history, yes. But that is what this resolution seeks to do and seeks to acknowledge. Further questions or comments on the bill from anyone who has not spoken on the bill yet? Further questions or comments? If not, Representative Fishbein, briefly for the second time.
Sure. Thank you, Mr. Chairman. I just heard you tell us that exoneration is not part of this resolution. However, I just wanted to read lines 15 through 17. Now, therefore, be it resolved that all of the formerly convicted and executed are exonerated of all alleged crimes relating to the charges of witchcraft. So by the resolution, by the actual language, I agree it has no legal effect, but we are expressly exonerating. And it's not only the charges of witchcraft, but it's charges related to witchcraft, which we have no idea what that is. So I understand where we are. And I think you have solidified my opposition. Thank you, Mr. Chairman.
Well, I'm glad I could solidify your opposition, Representative. I think my point still stands that obviously we cannot, you're correct, we cannot legally exonerate someone for charges, no more so than we could legally exonerate someone for a conviction they suffered or a conviction in the state of Massachusetts, for example, under Massachusetts law currently. But I think in that context of line 16, the term exoneration again is a recognition of the fact that in most of these instances, these individuals were convicted for conduct that would not be considered criminal, including having marks on their body of being a witch. Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on House Joint Resolution 34 to JF it to the floor. Winfield,
Winfield, yes.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel.
Yes.
Fishbein. Blumenthal. Callahan,
No.
Conley, Curry, Delaney,
Yes.
Dillon,
yes,
Doucette,
Yes.
Dubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Hall,
No.
Harding, Hayes, Howard, Johnson,
Yes.
Khan,
Khan is yes.
Labriola, Lesser, Mar,
Mar votes yes.
Miller,
Miller votes yes.
O'Day,
O'Day votes no.
Osborne,
Osborne votes yes.
Havelock D'Amato,
Tomato votes no.
Porter, Sampson, Sims,
Representative Sims votes in the affirmative.
Beach,
No.
Walker, Wilson.
Wilson votes yes.
Moving on to item number 14 on our agenda, House Joint Resolution number 261, resolution proposing an amendment to the state constitution to revise requirements related to the offering of bail or pretrial release to persons accused of a crime. Motion is a JF. Motion from Senator Winfield, second
Second.
from Representative Quinn. This resolution before us proposes an amendment to an outdated provision of our Connecticut state constitution. Right now, under Connecticut's current construct of the constitution, the only individuals who can be held without the possibility of bail are those who are accused of a capital offense. Our statutes have repealed all capital offenses, which means there is no ability for this legislature to prescribe any rules to hold anyone without bail. So, as was pointed out during the public hearing, if someone brutally raped someone, was released on bail, brutally raped someone again, they would still be entitled to bail, to be out for the third time. Under Connecticut law, currently, if Adam Lanza had walked out of Sandy Hook Elementary School, he would have been allowed bail under Connecticut law. Our system, because of our antiquated constitutional provision, is broken. There's not an ability to, at the high end, hold individuals pre-trial who should be held to reasonably assure their appearance in court and to protect public safety. Conversely, we still have far too many folks who are held on low levels of bail for low-level crimes which they cannot afford. Imposing a bail of $2,500 on someone might allow me out on bail, but might not allow one of my neighbors out on bail. And our system does not look at ability to pay. It doesn't look sufficiently enough at the risk to public safety of someone or what bail is intended to do, which is to assure their appearance in court. Someone with higher means has more means to flee a jurisdiction than those that don't, and we don't sufficiently take that into account under our current bail construct. It is past time for this legislature to have a very honest conversation about our bail system, to look at whether the system is working both at the high end and at the low end. I don't think it is. I don't have the magic bill that says this is how we're going to fix it, because frankly, we can't propose that bill under our current construct, because this legislature and this committee's hands are tied by an outdated constitutional provision that needs to be updated. This resolution is the first step of that process. It allows us to update the Constitution to give the legislature the flexibility to meet and to debate an honest amendment to our bail system here in the state. Questions, Representative Fishbein?
Thank you, Mr. Chairman. I agree with everything you said. You know, there is a concern. You know, at one end of the spectrum, we have the tragedy in Sandy Hook, and currently under our laws, if that was to happen tomorrow again, which we all pray that it didn't, the perpetrator, if they lived, would be entitled to bail. And under our current system, that bail cannot be punitive. We have a Supreme Court case that recently said that the bail must be there to reasonably assure the individual is able to appear for trial, but also to be able to participate in their own defense, which incarceration is deemed to be not that level of being able to cooperate. You know, so therefore at that end, I am in support that we need to do something. The concern, though, as has been expressed by members of my caucus, as well as many, many people in the industry outside of this building, is that should this pass, that the legislature will get rid of bail. And just, you know, through you and to you, Mr. Chairman, my understanding is that without this provision, the legislature could pass a law that says that if you're arrested for any number of offenses, that there is no bail. Is that true?
That's my understanding, Representative. In fact, I think that fear, I heard that at the public hearing, and I've heard that being spread in the hallways. That fear was already there. I mean, my understanding is there's nothing stopping this committee and then ultimately this legislature from passing a law right now that said, but for in B felony or higher cases, there will be no bail. We could do that under current law. What we can't do is address the higher end of the spectrum because of the construct of the Constitution. And so to me, it seems like if you're going to address one, you should address the other as well.
No, I appreciate it. And I think it's important to state that for the record to quell some of the discussions that I've been hearing. I mean, we've been working on this and we have other bills involving bail on this agenda. And I appreciate the discussions that we've had as leaders of this committee at both ends. So I am in support and I do intend to vote in favor. Thank you.
Thank you. Senator Kissel.
Thank you very much, Chairman Staffstrom. And I appreciate what you stated for the record and the colloquy that you just had with my friend and colleague, Representative Fishbein. A little bit of a opening Pandora's box, though. I just don't see the pressing need to change the Constitution at this time. From a purely partisan perspective, Republicans have very small numbers in the House and Senate. I don't see that changing dramatically anytime soon, but I'm happy to be proven wrong on those counts. But having this go then to completely be reconfigured is an open-ended proposition that I'm not so sure I'll be happy with the ultimate conclusion. That doesn't mean that folks that are pushing for this don't have the best of intentions at heart. I certainly believe that. I would never question motivation at all. Ad hominem attacks are absolutely forbidden in the House and Senate in this legislature, and for very good reason. But it's sort of like, you know, a trust fall, like we're behind, go ahead, trust us, and you're not going to hit the ground. And probably not, but maybe yes, I don't know. And staring at me in the face is places like New York City, not that far away, where it's all turned upside down. I go out and I talk to people in retail in particular, and they just are so sort of given up on the judicial system that they don't even prosecute people that go in and shoplift and things like that. They just, now it's so it gets written off and through the tax system. I mean, ultimately we bear those costs one way or another. Are there too many individuals maybe waiting to go to trial that are stuck in jail because of a bond that they can't afford? I bet you, yes. I don't even argue that. Yes. Should we be about forming a task force or a blue ribbon commission or all of us coming together and saying, how can we remedy that within the ambits of the laws that we currently have, within the parameters of the Constitution that we currently have? We probably can fix that or remedy that, make it better, make it fair. And trust me, I'm not living life large. I'm not complaining because I have a roof over my head, but you know, even what some people in this room might consider a modest bail amount, I might have a hard time struggling with. And so I'd be cool in my jets waiting for a trial while everything else in my life is falling apart, because it's not just the individual, it's everybody whose lives are touched by that. So that's a huge thing. I get that. On the Adam Lanza thing, I don't see a huge issue there. Theoretically, there might be a propensity for people circling through and committing lots more crimes while they're out. But I don't see that as the high-end serious crimes, that the problem there has anything to do with a revolving door regarding bail. There's plenty of things in the system that I can point to regarding that situation, but that's not sort of the top of the list. My understanding, and there was really only a handful of individuals that came and testified on this, and they said that versus other states, and we live in this wonderful nation where there's 49 other laboratories for change, that we're actually doing pretty good. And if anything, if someone has an FTA failure to appear, do we rigorously go after them? And that's a whole nother question, right? I mean, what good is it if we have these laws that say you have to come back to court, forget about the bail amount, and we don't even have the ability or the resources or the commitment to go and bring them back to court to stand trial? So to me, it's a little bit like signing a blank check and saying, okay, don't spend too much. And I don't know what the net result's going to be. I'd love it if I knew that the intentions of Representative Fishbein and Chairman Staffstrom were the ones that would be effectuated, but this is sort of a multi-year process. And fundamentally, I just have cold feet at this time. And for those reasons, Mr. Chair, with the utmost respect and admiration for my colleagues on this committee and throughout the legislature, I'm going to have to vote no. Thank you, sir.
Further questions or comments on this bill? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on House Joint Resolution 261 to JF it to the floor. Winfield,
Winfield, yes.
Staffstrom.
Yes.
Flexer. Quinn,
Yes.
Kissel,
No.
Fishbein,
Yeah.
Blumenthal, Callahan,
No.
Conley, Curry, Delaney,
Yes.
Dillon, Doucette,
No.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist. Godfrey. Hall.
No.
Harding. Hayes. Howard.
No.
Johnson.
Yes.
Khan.
Khan votes yes.
Labriola. Lesser. Mar.
Yes.
Miller.
Yes.
O'Day.
O'Day votes no.
Osborne.
Osborne votes yes.
Pavlock D'Amato.
Pavlock Tomato votes no.
Porter. Sampson. Sims.
Representative Sims votes yes.
Veach.
No.
Walker. Wilson.
Wilson votes yes.
Turn to item 15, House Bill number 5824, an act reforming the bail system, JFS LCO number 6413. Motion from Senator Winfield, second from Representative Sims. The JFS language to this bill removes the second piece to it. So the provision remaining in this bill based on the LCO language reforms the professional bail bond and surety bond system by requiring bondsmen and agents to establish and maintain trustee accounts and ensures penalties for failure to do so. Is there discussion on this bill? Is there discussion? Representative Callahan.
Thank you, Mr. Chairman, and I do intend to support the bill. Ever since the court started taking a 10% cash at the clerk's office under 20,000, it created a shortage of bonds that the bondsmen are writing, and therefore they've begun undercutting each other. Not all, but some, and this will hold people accountable to the parameters that are in place through the insurance commission to make sure that they're all abiding by the same rules. I think it's a good bill. It should pass.
Further discussion? Further discussion? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5824. JFS it to the floor with LCO 6413. Winfield.
Winfield, yes.
Staffstrom.
Yes.
Plexer. Quinn.
Yes.
Kissel.
Yes.
Fishbein.
Yeah.
Blumenthal. Callahan.
Yes.
Conley. Curry. Delaney.
Yes.
Dillon. Doucette.
Yes.
Dubitsky.
Yes.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey. Hall.
Yes.
Harding. Hayes. Howard.
Yes.
Johnson.
Yes.
Khan. Labriola. Lesser. Mar. Miller.
Yes.
O'Day.
O'Day votes yes.
Osborne.
Osborne votes yes.
Pavlock D'Amato.
Pavlock Tomato votes yes.
Porter. Sampson. Sims.
Sims in the affirmative.
Veach.
Yes.
Walker. Wilson.
Wilson votes yes.
Item 16, House Bill number 6569, an act concerning the minimum age to be eligible to marry. I'll entertain a motion for JF.
Second.
Motion from Senator Winfield, second from Senator Kissel. This bill would do as the title says. It would require that an individual be 18 years of age in order to be eligible to get married in the state of Connecticut. Questions? Representative Fishbein.
Thank you, Mr. Chairman. So, unfortunately, all too often we see entities coming into the state of Connecticut, taking a position, representing a harm that needs to be addressed. One would believe by reviewing the backup documents that tons of 16 and 17-year-olds are being married in Connecticut. However, the truth is that in 2018, the law was changed. And it may have been a problem prior to 2018. And I'll represent that, at least in the House, we voted for it unanimously. I believe the Senate as well. And that law created a procedure that if one wanted to do that, they couldn't just do it. They had to go to the probate court. The probate court had various things that needed to be proven before it permitted the marriage. One of the advocates, one of these out-of-state individuals, put in their backup information. They actually claimed that this was an urgent crisis. I quote. And when they came here to the public hearing, I asked them about the crisis. And they admitted that 31 people since 2018 had gotten the permission of the probate court. They couldn't identify a crisis, nor could they identify urgent. I asked everyone that came before us, give me one of those files that you thought should not have happened. Nobody could. It's a manufactured problem. I don't want anybody to be married at any point. No, I paused. The pause.
Representative will, I hope your wife is not watching.
30 years. No, I think it's 31 this year. No, I mean, the pause was for a breath. But my point is, without their assent, what we heard was that, you know, there's arranged marriages and people are forced into doing this and human trafficking. And yes, those things could occur pre-2018. I am not aware of, I don't believe anybody on this committee is aware of, and I'm certainly willing to hear about the story where this should not have been permitted post 2018. There are certainly situations where that in an assenting relationship should be permitted. We have the issue of the emancipated youth, where, you know, a court has adjudicated that individual to have the rights of an adult. And now we're telling them that it doesn't matter, even though you've been adjudicated to have that legal status, government's going to step in and take it away from you for this one particular thing. That doesn't make sense. We also have the individuals who, you know, perhaps someone is ill. You know, once again, don't want people to be unduly coerced or coerced at all unreasonably to enter into marriage. But you have the probate court and the gatekeeper function. And it isn't just, you know, file an application and you get a stamp. There's a whole list of things that need to be proven. You have the individual who's going off to war and, you know, wants to marry because they don't know what's going to happen when that person goes outside this country. And they want to have that benefit, and perhaps for benefits and those kinds of things. That's something that's happened. And, you know, and all those marriages, do they succeed? No. But what we have here is not a crisis. It's not an urgency. 31 people in 5 years have availed themselves of this process that nobody has shown to us doesn't presently work. It's unfortunate. You know, we have outside groups that are fundraising off of this, you know, that we're gonna, you know, make marriage before 18 banned in Connecticut. And that's unfortunate. That should not be our process. But, you know, there's some 19-year-olds and some 20-year-olds that shouldn't be married either. But that is their lawful choice. I don't know why we're arbitrarily selecting 18 for this. And we talked about 25 for something very, very different and serious earlier on. So I understand the position of the advocates, but I do not support where we are. So thank you, Mr. Chairman.
Further questions, comments, Representative Trubisky?
Thank you, Mr. Chairman. I encourage everyone to get married because I don't want to have to sleep on the couch tonight. This bill shows again how we are all over the map with regard to dates. It shows that we as a government want to get involved in people's lives in some things, but not in other things. We passed a bill a couple years ago that allows children to choose to have surgery without their parents' consent, to lop off parts of their body. But under this bill, they can't get married. How could we possibly look our constituents in the face and say a child is sufficiently mature to choose their own sex and to have parts of their body permanently removed, but they're not old enough to decide whether or not to get married? I would not find a single person in my district who said that made any sense. Frankly, I'm not sure that government really has a role in marriage anyway. And the less that we could be involved in marriage, the better. But telling people that they absolutely cannot, under penalty of law, get married, even if they've gone through the process that we established a couple of years ago, where they have to go to court in order to get approval of their own circumstances, it baffles me, frankly. Especially since the process that we established appears to be working fine. We did not hear any testimony of any abuses or a breakdown of that system. 30 some odd people in 5 years. Sounds like the system works to me. Why are we now banning it? I haven't heard an answer. Doesn't make sense. Thank you, Mr. Chairman.
Further questions or comments, Representative Osborne?
Thank you, Mr. Chair. In advance, I'm going to be voting this vote yes out of committee today, but in so doing, I want to say that I'm voting out of committee because I think it's a really important issue. I have no interest in people under the age of 18 marrying, and yet I'm also cognizant of our state constitution and our state statute that has reinstated the test of strict scrutiny to any laws that, even laws of a general applicability, that touch religious exercise and the exercise of religious freedom and religious belief. So I really hope that once this is passed out of committee, that the proponents of this bill will do the work necessary to make sure that this bill is constitutional as applied. And thank you very much for your time, sir.
Representative Godfrey.
Thank you, Mr. Chairman. If I understand this correctly, no marriage under 18, period. Am I correct?
You are correct.
There's no exceptions. So even if there's a pregnancy involved, they can't get married. We're creating, sorry for my language, a statutory set of bastards. We've got children being born out of wedlock because it's prohibited by state statute. Now, I'll vote to get this out of committee today, but this needs a significant amount of work, and that certainly exceptions and how those exceptions are enforced are part of it. Because it just troubles me very much. You know, when my father gave me the talk, the whole question of pregnancy came up, and the answer my father gave to me was, "And you will marry her." Not been a problem, but it still bothers me when we make sweeping changes like this, that I don't think we've explored all of the ramifications of it. So as I said, I'll get it out of committee today, but boy, I sure hope this gets rewritten. Thank you.
Further questions or comments on this bill? Senator Winfield?
Thank you, Mr. Chair. I appreciate all of the comments about the bill. I think the opposition or the concern about this bill is in evidence as bipartisan across different ideologies. And so I think if this bill is ever to actually see the light of the chamber and a vote passing both chambers, I would encourage those who have concerns and those who want the bill to have a serious sit down and a discussion and bring back to us a product that might be workable. Just a word of encouragement. Thank you, Mr. Chair.
Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 6569 to JF it to the floor. Winfield,
Winfield, yes.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel. Fishbein. Blumenthal. Callahan.
Yeah.
Conley. Curry.
Yes.
Delaney. Dylan.
Representative Delaney votes yes.
Dylan.
Dylan votes yes.
Doucette.
Doucette, yes.
Dubitsky.
No.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey. Paul.
No.
Harding. Hayes.
No.
Howard.
Yes.
Johnson.
Yes.
Khan. Labriola. Lesser. Mar.
Yes.
Miller.
Miller votes yes.
O'Day.
O'Day votes no.
Osborne.
Osborne votes yes out of committee.
Havelock D'Amato.
Havelock D'Amato votes yes.
Porter. Sampson. Sims.
Sims votes in the affirmative.
Beach.
No.
Walker. Wilson.
Wilson votes yes.
Moving on to number 17 on our agenda, House Bill number 6570, an act concerning damages to person or property caused by the negligent operation of a motor vehicle owned by a political subdivision of the state. It's a JF, motion for a JF. The motion is from Senator Kissel. The second is from Senator Winfield. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, we did discuss a oral amendment of this bill, but I'm looking at the language and I believe it already bakes in that, and I just wanted to, and I know we didn't discuss about that. I just saw it, so I'm not, is effective from passage and applicable to any civil action pending on or filed on or after the effective date of this section, which would address the concern and the amendment. However, the bill before us does not have an effective date. So I don't know how you want to, I mean, I know we usually do July 1 and October 1.
No, Representative, we do have bills that are effective on passage. We can have LCO confirm, but I believe what that means is that's the date that it is actually codified as a public act. No, I believe that's the date the governor signs the bill. And then, so whatever that date is that the governor actually signs it, it becomes effective as of that date. LCO, can you back me up on that?
That is correct. Okay, so passage as defined here is not passage by House and Senate, but it includes the governor's signature, because that's, I took it to be the effectiveness of a law is not until all three happen.
Correct. It has to be all three. So this would be a House bill, so it needs to pass the House, needs to pass the Senate, and then it would be effective upon the governor's signature.
Okay, so I'm comfortable then, and I'll cede the microphone for the moment.
Senator Kissel?
Thank you very much, Chairman Stafford. Well, this is nothing new. We've seen this before. It passed both chambers with huge majorities last time, and I'd like to encourage the governor's office, if he still has issues, talk to representatives of the trial bar. But fundamentally, when I drill down to the policy, I see nothing different than the reasons that I thought were valid a year ago. And fundamentally, it's why I take the position that I do on so many bills that come before us, essentially regarding access to justice. Does it matter if I'm injured, if the vehicle was a public works vehicle that's owned by a town or a public works vehicle that's owned by the state? Well, I guess I have a valid action if it's owned by the state, but for some reason, municipalities have been able to go along and essentially, I'm going to say it, shirk their responsibilities. And whether this has always been the case, it's sort of in the back of my mind that maybe some court decisions sort of shifted the ground here. But fundamentally, I want people, especially if they're harmed through negligence, to be able to bring their claim and seek redress. And we have a duty to have the doors to the courthouse open for our constituents. And so it's just as simple as that. And if you can make your case, great. If you can't, then you can't. But certainly there shouldn't be a carve out just for towns as opposed to pretty much every other entity. And that's why I strongly support this bill. Thank you, Mr. Chair.
Thank you. Further questions or comments on this bill? Further questions or comments? If not, I'll just associate myself with the remarks of Senator Kissel for the record. I think this really is an issue of where do we draw a line in terms of protection of those who are injured most often in car accidents, who are the sort of the unintentional victim of a car accident, and is a situation where without this bill, folks are denied even getting into the door to the courthouse. This is not imposing additional liability on municipalities. What it is doing is allowing them access to justice, access to the day in court, which is something that I hope members of this committee will support. Madam Administrator, please call the roll.
Roll call vote on House Bill 6570 to JF it to the floor. Winfield,
Winfield, yes.
Staffstrom.
Yes.
Flexer, Quinn,
Yes.
Kissel. Fishbein, Blumenthal, Callahan,
No.
Conley, Curry,
Yes.
Delaney,
Representative Delaney votes yes.
Dillon, Doucette,
Dillon, yes.
Doucette, Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Harding, Hayes, Howard,
No.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller,
yes,
O'Day,
O'Day, no.
Osborne,
Osborne, yes.
Havelock D'Amato,
Havelock D'Amato votes no.
Porter, Sampson, Sims,
Sims votes in the affirmative.
Veach,
Yes.
Walker, Wilson.
Wilson votes yes.
Item number 18, House Bill number 6571, an act concerning the authority of the court to enter an order of support for an adult child who has an intellectual or mental disability or who is physically disabled. It's a straight JF. Motion from Senator Winfield, second from Senator Kissel. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, as you may recognize, since I've been up here, I've attempted to be an advocate for especially autistic children. I think it's really important that when, two parties get divorced and there's going to be an order of child support, and the parents know that the child is not going to be gainfully employed, it's unfair, in my opinion, that child support is capped at the age of 18. That child's not going to college. There may be some job skill training and that kind of stuff that goes on, but I know, in my particular situation, my family situation, that child more than likely will not be employed outside the home. And our process currently leaves the primary custodial parent, which is many times mom, although in those situations, the one time that I agree to bird nesting, where the child stays and the parents are going in and out instead of the child transporting, that financial support should not just go away prematurely, in my opinion, at the age of 18. So it's before us. It permits, it doesn't mandate, it permits a court to order child support up to the age of 26. So one may say, well, why 26? That's the age that we use for health insurance usually. Although child support may go away, college expenses may be there. Presently, a lot of times we have the children stay on the health insurance until they reach the age of 26, because with the anticipation that child gets out of college, gets a job, and has their own health insurance. So you need a strong transition. So I think what's before us is very strong, and it sends a clear message of public policy in this state that we recognize the challenges of raising a child who's autistic. So thank you.
Further questions or comments, Representative Osborne?
Thank you, Mr. Chair. I strongly support this bill. And I'd like to bring to the attention of this committee that children at the age of 18 do not miraculously stop being supported by their parents, regardless whether their parents are married or divorced. And yet in the state of Connecticut, regular child support goes to the age only of 18, especially in the post-COVID world. There are a lot of children right now reaching the age of 18 who are neither socially nor emotionally sufficiently developed or ready to leave the nest at the age of 18, whether it's to go off to work full time to become self-supporting, or whether it's to go off for college. A number of young men and women I know who are reaching that age are electing to forego college, to take a gap year, or just simply are not ready to leave home yet. And statistically speaking, that burden falls disproportionately on the shoulders of the mothers who tend to be the primary custodial parents. In this state of Connecticut, our great state of Connecticut, 40% of the single mothers in this state live in poverty. This is one of the reasons. Divorced women in this country are a third more likely to retire into poverty than any other demographic in this country. This is one of the reasons. I think the time has come, has long since passed, for Connecticut primary custodial parents to be on par with their neighboring resident states of New York, where child support goes to the age of 21, and Massachusetts, where child support goes to the age of 21 and even 23 when a child is in an educational program. So I will fully support this bill as drafted, and I would like my colleagues to really strongly consider the statistics for single mothers in this state and give strong consideration to doing the right thing and getting child support raised to the age of 21 for custodial parents in this state. Thank you, Mr. Chair.
Further questions or comments? Further questions or comments?
Mr. Chairman.
Representative Bill.
Thank you, Mr. Chairman. To the proponent of the measure, would this apply to, as the language that I'm looking at, would this apply to a child with schizophrenia?
I believe so.
Thank you very much.
Representative Fishbein?
Yes, thank you, Mr. Chairman. Mr. Chairman, I make a motion that we move HB 6571, an act concerning the authority of the court to enter an order of support for an adult child who has an intellectual or mental disability or is physically disabled to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. Item 19, House Bill number 6676, an act concerning the penalty for commercial vehicles on state parkways. I'll entertain a motion for JF. I got a motion from Senator Winfield, and we're going to give a second to Representative Sims, who I know is used to driving that highway and used to seeing some of those trucks out there on that highway. And we're gonna give him some relief. Questions or comments on this bill? Questions or comments? Senator Kissel.
So is it my understanding that we're trying to dissuade certain behavior by raising a penalty by this bill?
I don't think we're necessarily seeking to dissuade behavior. What we're seeking to do is to have the penalty match with, at least to some level, with the offense. Right now, if a truck drives on the Merritt Parkway, most of the bridges on that highway are not high enough that the truck can get under. Also, most of the off ramps are so steep that trucks, if they're traveling at anything more than a crawl, will flip over and will jackknife. And what that does is every time one of these trucks gets on the Merritt Parkway or on the Wilbur Cross, it backs the highway up, oftentimes until multiple state troopers can come, can close the highway, can back the truck up to the on-ramp that it got on, and then can get it off, thereby causing hundreds of thousands of dollars in damages to the state of Connecticut in terms of lost productivity of our workforce, in terms of the resources where our state police are getting that truck off instead of chasing people for speeding or for other moving violations. And right now, the penalty for that for the individual who is charged is $90. $90. This would increase that to $500. I would submit 500 is still way too low compared to the disruption that that truck causes to our state. But it is a step in closing something of that gap between the disruption caused, the lost productivity, and what our current fine is. Does that answer your question, Senator?
Mr. Chairman, it does. I appreciate your answer. I just look at it like we want less of this behavior, and so we're going to increase the fine. I'm happy to support the bill. Thank you, sir.
Further questions or comments? If not, Representative Fishbein.
Mr. Chairman, I make a motion that we move HB 6676, an act concerning the penalty for commercial vehicles on state parkways to the consent calendar.
Is there objection? Is there objection? Seeing none, so ordered. Item 20, House Bill number 6714, an act concerning cruelty to animals, JFS LCO number 6319.
Second.
Motion from Senator Winfield, second from Senator Kissel. Discussion on this bill. Is there discussion on this bill? If not, Representative Fishbein.
Mr. Chairman, I make a motion that we move HB 6714, an act concerning cruelty to animals to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. 21, House Bill number 6737, an act establishing the crime of harmful communications with a minor. This will be a JF. Is there a motion?
Second.
Okay, I think I have a motion from Representative Sims, a second from Senator Kissel. Representative Callahan?
Just a brief comment, Mr. Chair. This is a bill that came through Judiciary last year and unanimously voted out of the House. Language hasn't changed, and it's And it's a good bill and I'll be supporting it. Hopefully, my colleagues will as well.
Questions or comments on this bill? Questions or comments? Representative Fishbein?
Mr. Chairman, I make a motion to remove HB 6737, an act establishing the crime of harmful communication with a minor to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. 22, House Bill number 6738, an act concerning compassionate or medical parole and credits awarded for release during an emergency declaration. It's a JF. Motion JF from Senator Winfield, second from Representative Porter. Senator Winfield.
Sorry about that, Mr. Chair. I was dealing with one of our other issues. This is a bill that has been before this committee before. We started working on this bill during the pandemic. It's creating a way of looking at and making determinations of medical and compassionate release, making modifications to the standards to determine when the inmate might be eligible for that compassionate parole release. And it looks at a system of credits for the release of imprisonment in times of what we would call an emergency declaration through you, Mr. Chair.
Discussion or comment, Representative Fishbein?
Yes, thank you, Mr. Chairman. You know, given recent events, recent disclosures before this committee, I don't know why this is necessary, given the position of the Board of Pardons and Paroles and their claim that they have certain statutory powers. I will tell you, I mean, I remember working on this during the pandemic. I believe I supported the language during the pandemic because I recognized that during a pandemic, certain things should be considered outside of the norm. I do question why, you know, emergency declaration can be issued if there's going to be a hurricane, right? So, you know, unless that hurricane is going to affect the area that that individual is in, this language opens up the permission for this to occur. I think we need to have a very, well, hopefully it isn't lengthy. We certainly need to have a comprehensive discussion about this process. You can't have it both ways. You can't come to us and say, we can do anything we want. We don't have to come to you. We can just make rules and call them policies, even though I believe they're regulations. And then say, well, we can't do this because we're constrained. It doesn't make sense. So, you know, the Board of Pardons and Paroles is created by statute. They have the powers that we give them by statute. Statutes presently provide that they have what has been determined to be a wide berth. So I find it's a bit ironic and hypocritical at the same time that we're being asked to pass this by law. Then if this is required, then their ability to do certain things are constrained. So I still don't know how I'm voting on this. It's before us today. I do support the policy. I don't know to the extent that's before us because of the, you know, the hurricane sort of situation, but I thank you, Mr. Chairman, for the ability.
Senator Winfield.
Thank you, Mr. Chair. And I actually take a lot of what you said and agree with the representative. What I can tell you is that during the pandemic, there was a lot of concern about the state in releasing people in the pandemic. And so by intention, I will say that this is not to say there's a state of emergency where something blows through the state over the course of one day and does a lot of damage and we do a state of emergency because we need relief from the federal government, that kind of thing. This is something, at least again, by our intention, that's going to have a longstanding impact on the people of the state. And moreover, impact on the people who we have in our custody. Having said that, your point about what the Board of Partisan Parole can do is, as I've said in private conversation and in public conversation, is something that the current statute allows a lot of leeway. If we as a body don't like it, we have a lot of power to change that, and I am absolutely willing to engage in that conversation. But this bill that's before us is not generated by the Board of Pardon and Parole, so they're not the ones asking. And in fact, a legislator, if we look at sides of the aisle, on your side of the aisle and myself, which would be on my side of the aisle, have thought that we need to have policy in place because while we're figuring out what's going on with the Board of Pardons and Parole, we don't know when we have something happen. We didn't know that COVID-19 was going to affect us, and that was a process that took us a couple of years to get past. I would hate, because we don't have a process in place with the Board of Pardons and Parole that we are happy with or content with or works for us, that something happens in the interim and we can't find ourselves in a space where we're doing what we need to do. And so I think there needs to be clarity. And so because there needs to be clarity, we are here with this policy. Having said that, I understand why one who voted in the past might not want to vote for this. I would just encourage us all to think deeply about what it means to not have the policy in place. We've seen what it means to not have the policy in place. Thank you, Mr. Chair.
Further questions or comments on this bill? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 6738, to JF it to the floor. Winfield,
Winfield, yes.
Staffstrom.
Yes.
Flexer. Quinn,
Yes.
Kissel. Fishbein. Blumenthal. Callahan. Conley. Curry.
Yes.
Delaney.
Representative Delaney votes yes.
Dillon.
Dillon votes yes.
Doucette. Jubitsky.
No.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey. Paul.
No.
Harding. Hayes. Howard. Johnson.
Yes.
Khan. Labriola. Lesser. Mar.
Yes.
Miller.
Miller votes yes.
O'Day. Osborne.
Osborne votes yes.
Pavlock D'Amato.
Pavlock D'Amato votes no.
Porter. Sampson. Sims. Beach.
No.
Walker. Wilson.
Wilson votes yes.
All right, item number 23, House Bill number 6875, an act concerning the issuance of a state identification card or motor vehicle operator's license to a person being discharged from a correctional facility. Motion for JF. Motion from Senator Winfield, second from Senator Kissel. Discussion on this bill. Senator Kissel.
Thank you very much, Chairman Staffstrom. I would just say that at the public hearing, it was abundantly clear that having an identification is so critical in getting back into society after someone leaves corrections. And that we had inmates or former inmates come and testify that they were really psyched to get back on their feet and be law-abiding, productive citizens. And the mere lack of an identification card was a huge roadblock, just a stone wall. And it discouraged them and threw them totally off course. And while the ones that were here didn't say they turned to a life of crime after they got released, the last thing that we want to do after putting so much time and effort and resources into helping people be successful in reintegrating with society is, for lack of a simple identification card, throw their lives upside down. I forgot which particular Shakespeare play, but it came down to the lack of a horseshoe, changed the course of a battle, which changed the course of a war. And this is one of those little things that's easy to solve. We just haven't gotten there yet. So I appreciate the efforts of Chairman Winfield, but I'm hoping this is the final piece of the puzzle to get this over the finish line. And it's amazing what a positive impact this is going to have. Thank you, Mr. Chair.
Representative Fishman?
Thank you, Mr. Chairman. You know, you would think that we would not need a public hearing to bring to the powers that be's attention that you need an ID to function in this world. I sort of thought when I first came up here, my impression of corrections was rehabilitative, a bit of punitive, and then try and make those that were incarcerated productive members of society. But what we learned through that public hearing in particular, what I learned is there's a disconnect. How anybody could possibly think that somebody's been incarcerated for 20 years and you're going to release them without an ID and they're going to function and not recidivize, doesn't know what they're doing. I mean, one individual came before us and told us that while he was incarcerated, he had a different social security number. So they put him in with the wrong social security number. So when he got out, and they're trying to link stuff up, he can't get an ID because, you know, the guy drops off the face of the earth for the last 20 years, and then you're trying to get an ID. That person needs to eat. They need perhaps services of the state. You try to get services from the state without an ID, it's not happening. So now you've got an individual who's homeless, can't eat, and they become desperate. That is human nature. And what happens, well, I have no personal stories to tell you, but I can logically think that desperation leads to recidivism. That should not be what our goal is here. This is just the tip of the iceberg here. This is just a minor thing. This is not rocket science. The fact that somebody should be leaving prison with some way to get around and to live should be simple. You know, a few years ago, as connected to the Labor Committee that Rep. Porter was the chair, you know, I was appointed to the Commission on the Collateral Consequences of Having a Criminal Record. And there were, you know, meetings about the difficulties of surviving with a record. And I heard about IDs. That was 4 years ago. Who was listening? Obviously not those that should have been. So I'm fully in support of what's before us. And there's got to be a lot of changes. So thank you, Mr. Chairman.
Senator Winfield.
Thank you, Mr. Chair, and not to prolong it, but I do think it's important. Collateral consequences and the conversation 4 years ago, the first bill I put in, I think was like 10 years ago. And then we did another bill and here we are again. And it makes no sense. It should have been fixed after the first bill. You know, we have had several hearings this year where we talked about IDs, both in appropriations and here in judiciary, and we've been brought some numbers about how great we're doing. And when you look at the IDs that the law has called for, it turns out we're not doing so great. Less than 40% of the people who get out have the IDs called for by the law. Look, whatever these people have done, and some of the stuff that people have done is stuff that none of us would have want anyone to do. Certainly when they get out of prison, what we want is to make it as effective, make our system as effective as possible at keeping them from going back into prison. And if we have them in our custody and we are saying they need IDs, it makes no sense to me that most of the people getting out don't have IDs. That many of the men who I have interacted with who get out show me this piece of paper with their face on it that you can barely make out. And that's the only ID that they have of any sort. It makes no sense. There's no reason for this. There never was a reason for it. And my hope is that not only do we get this out of this committee and pass it, but that it is clear to those who are supposed to be executing this that the only IDs that matter under the law are driver's licenses and non-drivers issued state IDs. Nothing else adheres to the law. Thank you.
Representative Jablonski.
Thank you, Mr. Chairman. When our judicial system should, and our corrections system should be geared towards corrections. There are many reasons to incarcerate somebody, and I'm not going to go through them all now, but one of them is some type of rehabilitation. Some people think that that's not possible. I don't agree with that, but regardless of the justification and the function of incarceration, I think most of us can agree that when a person gets out, society has an interest in seeing that person get back on his or her feet, get back into society, get back into being a productive member of that society. There may have been a time when it wasn't necessary to have official government issued identification to become a productive member of society. That is no longer the case. To get a job, to get services, to get very often housing, to get all sorts of things, you have to identify who you are. And if we essentially open the jailhouse door and say, you've served your time, have a good life, we're doing both the formerly incarcerated person and our society a grave disservice. There are many things that I think we should be doing, and many ways that I think we should be assisting formerly incarcerated individuals to get back into society. And I think this bill is one small step in that direction. Thank you, Mr. Chairman.
Further questions or comments? Further questions or comments? Representative Fishman.
Mr. Chairman, I make a motion that we move HB 6875, an act concerning the issuance of a state identification card or motor vehicle operator's license to a person being discharged from a correctional facility to the consent calendar.
Objection to place this item on consent. Is there objection? Seeing none, so ordered. Item 24, House Bill number 6887, an act concerning additional legal protection for victims of domestic violence. This is a JFS LCO number 6383. Motion from Senator Kissel, second from Senator Winfield. The JFS language removes much of the bill except for the GPS monitoring component. Discussion? If not, Representative Fishman.
Mr. Chairman, I move that we move HB 6887, an act concerning additional legal protections for victims of domestic violence to the consent calendar.
Is there objection to place this item on consent? Is there objection? Seeing none, so ordered. All right, before everybody gets too excited here, the chairs and the rankings, we are going to stand at ease for 2 minutes while the chairs and the rankings consult with LCO.
Robin. Did you get that email? Hi, Bob.
So we're not gonna start before 11.
All right, folks, I'd like to call us back to order. I guess in the vein of witchcraft, I expressed my sympathy to the committee for having to do this, but we have a member who was not here. Apparently was not in caucus. and has decided now to remove nearly half a dozen items from our consent calendar. So with deference to the other members of this committee, we are now going to have to roll call those bills. We will start with item number 4. We already have had a motion. We've already had discussion, so there will be no discussion on these. We will simply have to roll call these individual instead of being on a consent calendar because that member was not here for a meeting. Item number 4, Senate Bill number 1023. Madam Administrator, call the roll.
Roll call vote on Senate Bill 1023 to JFS it to the floor with LCO 6305. Winfield,
Yes.
Staffstrom.
Yes.
Flexer, Quinn. Kissel, Fishbein. Blumenthal, Callahan.
Yes.
Conley, Curry, Delaney,
Representative Delaney votes yes.
Dillon,
Yes.
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Hall,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller,
Yes.
O'Day,
Yes.
Osborne,
Yes.
Havelock Tomato,
Havelock Tomato votes yes.
Porter, Sampson, Sims,
Sims votes in the affirmative.
Beach, Walker,
Yes.
Wilson.
Yes.
Stay close, folks. Number 6 will be the next one we are forced to roll call now. That is Senate Bill number 1072. When you're ready, Madam Administrator.
Roll call vote for Senate Bill 1072 to JF it to the floor. Winfield,
Yes.
Staffstrom.
Yes.
Flexer, Quinn,
Yes.
Kissel. Fishbein. Blumenthal, Callahan.
Yes.
Conley, Curry, Delaney,
Representative Delaney votes yes.
Dillon,
Yes.
Doucette,
Yes.
Dubitsky. Elliott, Gaston, Gilchrist.
Yes.
Senator Gaston, thank you, Senator. Gilchrist, Godfrey. Hall,
Yes.
Harding, Hayes, Howard, Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller.
Which bill is this, please?
This is Senate Bill 1072.
Thank you. Yes.
O'Day,
Yes.
Osborne,
Yes.
Havelock Tomato,
Havelock Tomato votes yes.
Porter, Sampson, Sims,
Rep. Sims votes in the affirmative.
Beach,
Yes.
Walker. Wilson.
Yes.
Whenever you're ready, Madam Administrator, we will next turn to item number 7, which is Senate Bill number 1119. That was a JFS LCO 6311. We'll roll call that, please.
Roll call for Senate Bill 1119. Winfield,
Winfield, yes.
Staffstrom.
Yes.
Flexer, Quinn,
Yes.
Kissel. Fishbein. Blumenthal, Callahan, Conley, Curry, Delaney,
Representative Delaney votes yes.
Dillon,
Yes.
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Hall,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller,
Yes.
O'Day,
Yes.
Osborne,
Yes.
Havelock Tomato,
Havelock Tomato votes yes.
Porter, Sampson, Sims,
Sims votes in the affirmative.
Beach,
Yes.
Walker. Wilson.
Wilson votes yes.
Madam Administrator, number 10 on our agenda, Senate Bill number 1194. The action was a JF. Please call the roll.
Roll call vote on Senate Bill 1194. Winfield,
Winfield, yes.
Staffstrom.
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yes.
Fishbein, Blumenthal, Callahan,
Yes.
Conley, Curry, Delaney,
Representative Delaney votes yes.
Dillon,
yes,
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Mar votes yes.
Yes.
Miller, O'Day,
Yes.
Osborne,
Yes.
Pavlock D'Amato,
Pavlock D'Amato votes yes.
Porter, Sampson, Sims,
Sims votes in the affirmative.
Beach,
Yes.
Walker,
Yes.
Wilson,
Wilson votes yes.
Madam Administrator, number 19, House Bill number 6676. The action was a JF. When you're ready, please call the roll.
roll call vote on House Bill 6676. Winfield,
Yes.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel, Fishbein, Blumenthal, Callahan,
Yes.
Conley, Curry, Delaney,
Representative Delaney votes yes.
Dillon,
yes,
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller,
Yes.
O'Day,
Yes.
Osborne,
Yes.
Pavlock D'Amato,
Pavlock D'Amato votes yes.
Porter, Sampson, Sims,
Sims votes in the affirmative.
Beach,
Yes.
Walker,
Yes.
Wilson.
Wilson votes yes.
All right, now I think we are ready for our consent calendar. So, Madam Administrator, if we could compare notes on that, if you could read the consent calendar.
Consent can,
Oh, wait, hold on, Madam Administrator. Madam Administrator, when you're ready, you could read the consent calendar, please.
the consent calendar consisting of Senate Bill 5, Senate Bill 927 with LCO 6385, Senate Bill 1134, Senate Bill 1193 with LCO 6349, Senate Bill 1230, House Bill 6571, House Bill 6714,
Wait, hold on, go back. What was the one for that?
House Bill 6571,
How about 5824?
we did a roll.
We voted that one? Okay.
House Bill, so 6571, 6714 with LCO 6319, House Bill 6737, House Bill 6875, and then House Bill 6887 with LCO 6383. Okay. Roll call vote on the,
Wait, before anybody want to pull any of those off the consent calendar? The last, no? All right, please call the roll.
Roll call vote on the consent calendar. Winfield,
Yes.
Savstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel, Fishbein, Blumenthal, Callahan,
Yes.
Conley, Curry, Delaney, Dillon, Doucette,
Yes.
Dylan, yes.
Jubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller, yes.
O'Day,
Yes.
Osborne,
Yes.
Havelock D'Amato,
Pavlik Tomato votes yes.
Porter, Sampson, Sims,
Sims votes in the affirmative.
Beach,
Yes.
Walker, Wilson.
Yes.
That finishes up our business for today. Tomorrow, be on the lookout. The chairs will finalize an agenda and get that out shortly for tomorrow. We will be in tomorrow. The meeting is scheduled for 10, although I believe there'll be caucuses. Okay, the Republicans will caucus at 9. The Democrats will caucus at 10. Be on the lookout for details from your respective caucuses on that. I know there are other meetings in the morning, so we do not expect to actually take up business in this committee until at least 11 tomorrow. So although the meeting is scheduled for 10 and we will gavel in at 10, for members of the public, don't expect business until after 11. Caucus for the Republicans at 9 a.m., caucus for the Democrats at 10 a.m. And with that, we stand in recess until 5 o'clock for members to get votes in. Have a good night, everybody.
Yeah, it was funny. He didn't.
Representative. Oh, Representative Dillon.
Hi, I think I missed about 5, but I'm not sure.
Let me look right now. For Senate Bill 1071. How do you vote?
Yes,
And for Senate Bill 1195.
yes,
For House Joint Resolution 261.
Yes.
House Bill 5824.
Yeah, yes. Excuse me.
You're all set. Thank you so much, Representative.
Thank you.
Hi,
Representative.
Madam Clerk.
Representative O'Day for House Bill 6738.
What's the title?
6738.
Okay. 6738.
Which is item number 22, and act concerning compassionate or medical parole and credits awarded for release during an emergency declaration.
Yes.
Let's see, hello, Senate Bill 952.
I'm sorry, 6738. Yeah, yes. I'm sorry. What's the next one?
That's okay. Senate Bill 952, which is item 3.
No. Thank you, Madam Clerk. Am I good? What's that?
That's better? Okay, you switched here in the hearing room. So for, I have everything else, you're all set.
Oh, no.
You there?
Yes, can you hear me?
Yes.
So a no?
No, you're all set. I have you for all, wait, hang on one second. A no for which one?
Oh, for the parole?
For 6738. Okay. Okay. I have you a no for 6738.
Yes.
Okay. All right, perfect.
Yeah.
Then you're all set.
Thank you.
Thanks so much. Senator Gaston?
Yes, I think I missed a couple of votes.
So for Senate Bill 1071, and that concerning deceptive or coercive interrogation tactics.
Yes,
Senate Bill 1195, secondary traffic violations.
what is it?
Secondary traffic violations.
Yes,
Okay. All right, you're all set. I have you for everything else.
all right, thank you so much.
Thank you so much, Senator. Take care.
Hi, Senator Miller.
Hi, Kirsten. How are you?
Good, and yourself?
Good, thank you.
Senator Miller for Senate Bill 952.
That's a yes.
For Senate Bill 1071.
Yes. That should be it.
I think it is it. Yeah. Yeah, everything else looks good. You're all set. Thank
All
you.
right, thank you. See you tomorrow.
Take care, Senator. Representative Delaney
Good afternoon, Madam Administrator.
for the consent calendar.
Yes,
And then let me just double check for Senate Bill 952.
yes,
This. Um, let's look. You're all set. Thank you so much, Representative.
thank you, Madam Administrator, and you have a nice day.
You too. Representative Pavlik D'Amato. All right, for Senate Bill 952.
952, number 3 is a no.
For Senate Bill 1195.
1195, number 11, no.
House, nope, we got you there. Awesome, you're all set.
Thank you.
Thanks. Hi, Representative, can you hear me okay?
Yes, can you hear me?
Awesome. Yep. Let me just grab the tallies for you. Okay, so we've got, let's see. All right, for Senate Bill 952.
I vote yes. Jillian, do I have to say the thing? State representative, what do I say? Now I'm like, it's out of it. Representative Gilchrist votes yes.
All right, no, you're good. So these, okay, I think I did from the order. All right, so Senate Bill 1023.
Okay, I'm like looking at the thing. Representative Gilchrist votes yes.
So that what I should do too as well. So we put 5 and 927 on the consent calendar. 1 and 2, 3 and 4. We did roll 1071. We did a roll. How do you vote?
1071, hold on. Representative Gilchrist votes yes.
Okay. 1072.
Representative Gilchrist votes yes.
Okay. 1119.
Representative Gilchrist votes yes.
1134 was on consent. 1193 was on consent. Thank you. Senate Bill 1194.
That's not one. Oh, I see it. Okay. Representative Gilchrist votes yes.
Okay. 1190. Senate Bill 1195.
Representative Gilchrist votes yes.
State House Joint 34.
Representative Gilchrist votes yes.
House Joint 261.
Representative Gilchrist votes yes.
House Bill 5824.
Representative Gilchrist votes yes.
6569.
Representative Gilchrist votes yes.
6570.
Representative Gilchrist votes yes.
6571 was put on consent. 6676.
Representative Gilchrist votes yes.
67, let's see. 6714 is on consent. 6737 consent. 6738.
Representative Gilchrist votes yes.
And then the consent calendar.
Representative Gilchrist votes yes.
Awesome. Thank you so much.
Thank you. Have a good one.
You too.
Hello.
Hi, Representative. How are you?
Good.
All right. So consent calendar. How do you vote?
You want to start with the consent calendar?
You know what we'll
Yeah.
do is why don't we go through I'll go through the agenda with you really quick. So 1 we put on consent, 2 we put on consent, 952, Senate Bill 953, which is 3. How do you vote?
Yeah. Representative Khan votes yes.
Okay. 1023, item 4. How do you vote?
Representative Khan votes yes.
Senate Bill 1071,
Representative Khan votes yes.
1072,
Representative Khan votes yes.
1119,
Representative Khan votes yes.
1194,
Representative Khan votes yes.
11. See, I got you on 1195. Got you. Let's see, House Bill 5824.
Representative Khan votes yes.
And then 6569,
Representative Khan votes yes.
6570,
Representative Khan votes yes.
6676,
Representative Khan votes yes.
6738,
Representative Khan votes yes.
and then a consent.
Representative Khan votes yes on consent.
All right, you're all set.
Thank you.
Hi, Kirsten.
Hi, Senator, how are you?
Good. How are you?
Good. So I'm going to do all the roll as we go through with all four of you.
Great.
So,
Hi, May. Hey, Matt.
yeah, he's saying hi. So for Senate Bill 1119, which is item number 7 on the agenda, Flexer. Yeah. Blumenthal. Yeah. Harding
Yes.
and Sampson. Okay. For 1194, which is item 10, the sex offense registry. Enact relieving certain registrants of the requirements of the sex offense registry and clarifying registration requirements for persons transferred into this state and who reside in congregate care settings. Okay. Blumenthal?
Yeah.
Harding?
Yes.
Oh, Wester's not here. And Sampson. You know? Okay. Why it's not? It's okay. You want to wait? Okay. 1195. Senate Bill 1195, an act establishing secondary and traffic violations. Flexer? Yeah. Blumenthal?
Yeah.
Harding?
No. Sorry.
And Sampson? Okay. We've got House Joint 34, an act concerning a resolution concerning certain witchcraft convictions in Colonial Connecticut. Flexer? Yeah. Blumenthal? Yeah. Harding?
Yes.
Sampson? House Joint 261, resolution proposing an amendment to the state constitution to revise requirements relating to the offering of bail. Flexer? Yeah. Blumenthal? Yeah. Harding?
No.
And Sampson? No. Okay, and then House Bill 5824, an act reforming the bail system. Flexer? Yes. Blumenthal? Yeah. Harding?
Which number is this? I'm sorry.
That's okay, it's 5824, item 15.
Yes.
And Harding, yes, and Sampson. Okay, and then we've got 6569, which is item 16, Flexer. Yeah. Blumenthal. An act concerning the minimum age to be eligible to marry, sorry. Harding
Yes.
and Sampson.
Yes.
Okay. 6570, which is item 17, an act concerning damages to person or property caused by the negligent operation of a motor vehicle owned by a political subdivision of the state. Flexer? Yeah. Blumenthal?
Yes.
Harding
Yes.
and Sampson. Okay, and then 6676, which is item 19, an act concerning the penalty for commercial vehicles on state parkways. Flexer. I'm so sorry. An act concerning the penalty. Yeah. Blumenthal. Harding
Yes.
and Sampson. 6738, which is number 22, an act concerning compassionate or medical parole and credits awarded for release during an emergency declaration. Flexer. Yeah. Blumenthal. Yeah. Harding
No.
and Sampson. Okay, and then we had the consent calendar. So Flexer? Yeah. Blumenthal?
Yeah.
Harding
Yes.
and Sampson? Yes. Okay. So you're all set. Thank you. Senator Harding, if I could
Yep.
get you for Senate Bill 952.
Yeah. I am a no on 952.
Okay, you're a no here. And then 1023.
1023.
Number
I
4.
am a yes on 1023.
Okay, and then 1071.
1071. I am a no.
Okay, and then 1072, which is number 6.
I am a yes on 1072.
All right, you're all set.
Great.
so much,
Thank you.
Andrew. Yeah, take
Yeah,
care.
thank you. Appreciate it. Bye-bye.
Madam Administrator?
Hi, Senator, how are you?
I am good. How are you?
Good, good. So for Senate Bill 952, which is number 3,
Okay.
an act concerning parole eligibility for an individual serving a lengthy sentence for a crime committed before the individual reached the age of 25.
I am a yes.
Okay. For Senate Bill 1023, an act concerning probate court operations.
I am a yes.
Okay. And then let's see, Senate Bill 1071, an act concerning deceptive or coercive interrogation tactics.
I think did I already vote on that?
I don't have you in here. I don't have you written down.
What's that?
I don't have you checked off.
I'm a yes.
Okay. 1072. So just so you know, we had a handful of bills that were on consent that were pulled off and were voted on separately afterwards. So
Okay.
some of these you may have already known to have been listed, but are now separate. So
Okay.
Senate Bill 1072, an act concerning revisions to the Common Interest Ownership Act.
Okay. I'm a yes.
1119, which is an act concerning business registrations with the Office of the Secretary of the State.
What number is this?
This is 1119.
Okay. Yes.
Okay, and then 1194, which is item number 10, an act relieving certain registrants of the requirements of the sex offense registry and clarifying registration requirements for persons transferred into the state and who reside in congregate care settings.
I'm sorry. What number is this?
This is number 1194, so it's number 10 on the agenda.
I'm a yes.
Okay. Make sure I have the rest.
Actually, yeah.
And for House Joint 261, which is the constitutional, a resolution proposing an amendment to the state constitution to revise requirements related to the offering of bail.
I'm a yes.
No, it's not it. So I got you here. I got you here. 65. 1 second. All right. So for 66,
I'd like to. Yeah, I'm sorry. Say that again.
6676, which is number 19, an act concerning the penalty for commercial vehicles on state parkways.
I'm a yes.
6738, which is number 22, an act concerning compassionate or medical parole and credits awarded for release during an emergency declaration.
I'm a yes.
Okay, and then the consent calendar.
I'm a yes.
Okay, so go ahead.
Could I'd like to actually change my vote
Sure.
on number 10. I'd like to be counted in the negative.
Sure, I'll fix it right now.
Okay, great.
All right, you're all set.
Thank you.
Thank you so much, Senator.